matter will come on coming Thursday, Lordship.
Oh, acha.
They come today, Lordship. So
No
on
problem.
12, Lordship, on
21.
21, Lordship. I have already informed the petitioner's counsel, Lordship.
As jointly prayed,
Lordship.
relist this matter next Thursday.
12, yeah. Oblige, Lordship. Oblige.
Yes, Mr. Banik?
Manoj, so far as item number 8 is concerned,
It is for further hearing for you.
I need to
Yes.
file couple of applications, my lord.
You need to file couple of applications.
My lord, the applicant number 1 is not intending to contest,
Acha.
while the applicant number 2 has died.
All right.
My lord, may I pray
Ah.
for it as agreed to with Mr. Sabyasachi, my lord? Can I pray for 20th of this month in which we will file anything?
As prayed for by Mr. S. Banik, learned counsel appearing for the appellant with consent from Mr.
I am K. Vishwakarma on behalf of Mr. S.P. Chaudhary.
So and so learned counsel on behalf of Mr. S.P. Chaudhary, learned counsel for the respondent, relist
On 20th,
on 26.
26.
Yes,
And my lord, so far as item number 11 is concerned,
Oblige, ma'am.
Yes.
my lord, I could somehow manage to come to the court. My entire residence and the area of my chambers.
Under water.
Water. I somehow could manage. I
Item
had a word
11.
with but some other day, my lord, and it fits.
You are for the
Petition,
petition.
I'm for the petition.
Okay. Have you informed?
Yes.
In item 11, as prayed for by Mr. S. Banik, learned counsel for the petitioner with consent from the other side. Relist on, give a date because it's the old matter.
After vacation, any day.
Date of the DDB. On such and such date.
The interim to continue.
Interim, if any, will continue to
Right.
the next date.
Grateful. Deeply.
May it please, my lord. I beg to mention for listing a writ petition. Writ petition related to land matter.
Huh?
Oh, it's much.
Yes. Call the list.
Item number 1.
Mr. Sharma, matter from order of assembly. Yes, what is this, Mr. Khan?
Sir, I am aggrieved by the agreement which was entered into at page 36, my lord. Prior to that, my lord, page 36, this is the
1
agreement.
second. Respondents are represented.
Yes, sir.
Pleadings are complete.
They are 3 and 4. 1 and 2 is the District Legal Service Authority. As per the office note dated 30th of December 2019, service is complete.
But they are not appearing.
They are not appearing.
Then it's
Because
all
the
right.
records may be necessary because we have stated on a petition that if my lord may kindly
What is the issue?
issue, my lord, is there. First, my lord may kindly peruse, there is a complaint case which was filed under the Negotiable Instrument Act, that is at page 17.
No, firstly, what is that you are praying in this writ petition?
Praying
A
for-
quashing of the criminal case.
No, that I am not pressing upon. I am pressing upon the cancelling, setting aside of the award dated 13 to 2016.
By
of
the
of
Lok
legal-
Adalat.
Of the Lok Adalat.
That is what you are challenging.
Yes, but I am not pressing upon the quashing of the complaint case. Because
Mr. Mohanto, you are appearing for
3 and 4, Your Lordship. 3 and 4, respondent number 3 and 4.
private respondent
Yes, the persons who have signed a consent decree.
who has signed the consent
Decree.
decree.
I am from there.
Yes.
First of all, my lord, there was a complaint case which was filed at page 17.
Hmm.
This was
What records you want?
because it may be necessary because the
What records?
case records of the NI Act case and also the Legal Service Authority.
In which this consent order was passed?
Yes, my lord, because
Who
the
has to
CR
take this?
case,
Not necessary, Your
Then
Lordship. So I may submit.
because because the order sheet which I have annexed
Hmm.
at the complaint case is at page 17,
7017.
17.
Yes.
There, my lord, the private respondent, they have claimed that we had handed over taken an amount of rupees 4 lakhs from them.
Hmm.
Then thereafter, we had handed over a check which has dishonored.
Yes.
Thereafter, they had in the prayer portion at page 20, my lord, the check was of 4 lakhs and they have said that they have sought for an amount of rupees 8 lakhs.
Who is
That
the
is-
complainant in this case? Mr. Mohantas client?
Yes, my lord.
She
is respondent 3 here.
Prayer is?
For 8 lakhs, the check amount was of 4 lakhs.
All right.
So double the amount.
Yes.
So thereafter, my lord, the order sheet of that case, if my lord may kindly peruse at page 31,
Yes.
there are 4 orders
Yes.
which was passed, my lord. On all the 4 occasions, my lord, the complainant was absent.
Yes.
And it was fixed for the statement, that is the initial deposition of the complainant.
But on 5/12, it is not clear whether complainant was absent or not.
The order, my lord, the
5/12, page 31.
512. The SMEs is at page 32. It is-
Admitted fact, Mr. Mohanta, that the complainant was absent on 5/12?
Yes, sir.
All right.
Thereafter, my lord, down below at page 31, complainant is absent with step white petition number so and so, fixed 3/3 for 2016 for statement. Thereafter, my lord, on 13/2/2016,
Yes.
at page 33,
Yes.
the matter was sent to the Lok Adalat.
Both parties had amicably settled the
Yes,
case.
my lord. So it says that there were the matter was amicably settled between the parties. This is the 13/2/2016 order.
This is under challenge.
Yes, this order and the settlement which was arrived at page 36.
On what ground?
Now, my lord, what has happened? The agreement was that every year for a period of 4 years, the accused will pay amount of rupees 2 lakhs for a period of.
You have only signed the
No,
settlement.
there is an issue, my lord. Issue, my lord, is that.
Once you have settled it before the Lok Adalat, the
lord.
matter has attained finality.
My lord, may kindly peruse the
This
legal service.
settlement is not through coercion or anything, isn't it?
My lord, may kindly peruse. No, I have pleaded about coercion and all that, madam. In my pleadings, I have pleaded about that.
What? You have been forced.
I pleaded, my lord.
What have you pleaded?
Para 6, page 8.
Read.
Petitioners humbly state that the petitioner received a notice for appearing before the Lok Adalat, which was to be held on 13/2/2016. The petitioners initially were reluctant to appear before the Lok Adalat on 13/2/2016, but the respondent number 4, that is the husband, threatened the petitioner that if the petitioners do not appear before the Lok Adalat, then the petitioners would have to pay the double the check amount as mentioned in the prayer of the petition, and the petitioners may also be arrested, which will result in the petitioner number 1 being dismissed from service. The petitioner number 1 is a engine driver.
Have you filed any
No FIR.
FIR?
I had filed a complaint case, but that
Immediately.
was filed, my lord,
When did you file it?
in 2017.
That is after 1 year. Because February 16, this order was given.
Page 53.
It's a count, you are not inspired. It's a settled or constant
lord.
order.
No, my lord, my kind of,
After 1 year, you filed a complaint.
my lord, may kindly peruse page section 20 of the Legal Service Authority Act.
Yep, sir. আছে এখন। Section
20.
yes.
Where in any case referred to in clause 1 of subsection 5 of section 19, the parties thereof agree, or one of the parties thereof makes an application to the court. In this case, nothing, our party has not agreed that the matter should be sent to the Lok Adalat. One of the parties thereof makes an application to the court for referring the case to Lok Adalat for settlement. And if such court is prima facie satisfied that there are chances of such settlement, or the court is satisfied that the matter is appropriate one to be taken cognizance of by the Lok Adalat, the court shall refer the case to the Lok Adalat.
Where is the notice of appearance before the National Lok Adalat on 13/2/16?
That
Page
notice-
34.
34, man.
34.
34.
This is not a, this is the
This is a
order sheet. This is not a
records-
notice.
No,
Yes, sir.
this is the order at 34.
But this records that pursuant of the notice, both the parties have appeared.
Huh?
This record, case record is put up.
Correct.
Yes,
So
sir.
that's why this court is asking, where
Yes,
is
your
the
lordship.
notice?
That notice I do not have as of now with me, my lord.
No, the next.
That notice may have some
Otherwise, the record,
importance.
otherwise the record will be called for, my lord.
I think yes,
No,
the
records are
record should be
apparently are not
necessary.
necessary, your lordship. Why I say?
Why not necessary, Mr. Mohanta?
Because your lordship.
Because the order sheet
compromise-
doesn't show how this
That-
matter has gone to the National Lok Adalat.
Your lordship, what has
And
happened?
section 20 indicates that both parties if agree or one party is.
Question is that-
Now, how it has gone, let us have a look at
The
it.
question is that what your lordship,
Mm.
if I may submit your lordship, the order which has been passed, the compromise petition, they have been filed by both the parties. They have appeared there, they have signed there.
All right, now they have
Now-
challenged it. This court has to
Question is that,
adjudicate.
question is that can they challenge it? The,
You see, this is a matter which needs to be adjudicated now.
yes, your lordship, I agree to it, but
I'm
what
not
the
hearing
purpose of this court,
today. I'm not
I understand your lordship.
passing
but-
any adverse order today.
No, I understand your lordship, but the question is the award of Lok Adalat.
Can it be challenged?
Yes, your lordship, that is the thing.
Which section
Section 21.
of the
Sir.
Lok Adalat Act?
Yes, your lordship. If I may read it slowly, your lordship.
Yes.
Award of Lok Adalat. Every award of the Lok Adalat shall be deemed to a decree of a civil court, or as the case may be, an order of any other court, and where a compromise or
You are
settlement has been.
reading section?
21, your lordship. Award of Lok Adalat. Section
Yes,
21.
yes,
Lordship, you find it?
yes.
Yes, your lordship. Every award of the Lok Adalat shall be deemed to a decree of a civil court, or as the case may be, an order of any other court, and where a compromise or settlement has been arrived at by a Lok Adalat in a case referred to it under subsection 1 of section 20, the court fee paid in such case shall be refunded in a manner provided under the Court Fees Act 1870. Next, every award made by Lok Adalat shall be final and binding on all the parties to the dispute, and no appeal shall lie to any court against the award.
But this is a writ.
Writ.
Writ. Yes. You have a decision and
Yes, your lord.
authority that the writ petition is not maintainable.
Yes.
So.
Lordship, there's a judgment 2018-13 SCC 480, where it is challenged to award of Lok Adalat can only be filed 2018-13 SCC.
You have a copy?
No, your lordship. I'll just
Give the citation, we are you a party. You read it in your tab and you give me a photocopy.
Lordship, I have under not the latest decision, but it is a 2012 2 SCC that I can refer.
You want your matter to be heard and you are not prepared with the case laws.
Lordship, I'm
Ah.
prepared with the case law here.
But
Yes, sir.
where are the copies of the court?
I don't do the print. One
If
case
you,
law I
if
don't
you
do.
want to rely on case laws, then
Yes,
is
sir.
it not necessary for you to give a book list to the court master?
Lordship, actually,
Huh?
I've taken out the printouts of both the case laws.
That is your thing.
Yes, sir.
But these are basic things
Right,
which the councils are expected to do.
I
This is for the assistance of the court
I understand.
and not to unnecessarily waste the judicial time of the court.
Yes, sir.
These are the basic things. These things, if one starts taking it casually, it is going to be very difficult.
I apologize. Sir.
Yes,
Lordship, in this judgment, 2012 2 SCC 51,
yes,
page para 11, your lordship. Before that, I'll just read para 10,
yes,
if I may read your lordship.
yes.
The Act empowers the legal services authorities at the district, state, and national levels, and the different committees to organize Lok Adalats to resolve pending and pre-litigation disputes. It provides for permanent lok adalats to settle disputes involving public utility services. Under the Act, legal services have a meaning that includes rendering of service in the conduct of any court annex proceedings or proceedings before any authority, tribunal, and so on, and giving advice on legal matters. Promoting legal literacy and conducing legal awareness programs are the functions of legal services institutions. The Act provides for machinery to ensure access to justice to all through the institution of legal services authorities and committees. These institutions are manned by judges and judicial officials. Parliament entrusted the judiciary with the task of implementing the provision of the Act. This is the essence of the Act has been discussed. Next, Your Lordship, Para 11, Section 21 of the Act, which we have extracted above, contemplates a deeming provision. Hence, it is a legal fiction that the award of the Lok Adalat is a decree of a civil court. In the case on hand, the question posed for consideration before the High Court was that when a criminal case referred to by the magistrate to a Lok Adalat is settled by the parties and an award is passed recording the statement, can it be considered as a decree of a civil court and thus executable by that court? After highlighting the relevant provisions, namely Section 21 of the Act, it was contended before the High Court that every award passed by the Lok Adalat has to be deemed to a decree of a civil court and as such executable by that court.
Yes, 12.
Unfortunately, the said argument was not acceptable to the High Court. On the other hand, the High Court has concluded that when a criminal case is referred to the Lok Adalat and it is settled at the Lok Adalat, the award passed has to be treated only as an order of the criminal court and it cannot be executed as a decree of the civil court. After saying so, the High Court finally concluded that an award passed by the Lok Adalat on reference of a criminal case by the criminal court, as already concluded, can only be construed as an order by the criminal court. It is not a decree passed by a civil court, and confirmed the order of Principal Munsif, who declined the request of the petitioner therein to execute the award passed by the Lok Adalat on reference by a complaint by the criminal court. May I read further, Your Lordship?
Yes, please.
On going through the statement of objects and reasons, definition of court, legal service, as well as Section 21 of the Act, in addition to the reasons given hereunder, we are of the view that the interpretation adopted by the Kerala High Court in the impugned order is erroneous. It is useful to refer to some of the judgments of this court and the High Courts which have a bearing on the present issue. In Shubhas Naraspa Mangurule and Siddharampa Jagdeva Unnad, a learned single judge of the High Court of Bombay, considered an identical question. In that case, on 22/6/2001, the respondent filed a criminal complaint being SCC number 923 of 2001 in the Court of Judicial Magistrate First Class, Akal Court, under Section 138 of the NI Act. Later, the said criminal case was transferred to the Lok Adalat. The matter was compromised before the Lok Adalat and an award was passed accordingly for ₹4 lakhs. The respondent therein filed a Darkhast proceeding number 17 of 2006 in the Court of CJJD for execution of the award passed by the Lok Adalat in the criminal case, as there was no compliance with the compromise order stroke award. The learned CJJD issued a notice under Order 27 Rule 22 of the CPC. The petitioner therein raised an objection stating that the Darkhast proceeding is not maintainable as the award has been passed in a criminal case. By an order dated 18/7/2007, the learned civil judge, Junior Division, disposed of the objection and directed to proceed with the execution by the judgment and order. Aggrieved by the same, the petitioner therein filed a revision before the High Court. After adverting to Section 20 and other provisions of the Act, the learned single judge has concluded thus. The parties were fully aware that under the Act, the District Legal Service Authority may explore the possibility of holding pre-litigation Lok Adalats in respect of the check bouncing cases. The compromise in such cases would be treated as an award having force of a decree. All objections as raised with regard to the execution in view of the above statutory provision itself is rightly rejected. Having settled that matter in Lok Adalat and after more than 3 years, raising such plea is untenable.
In this case, it is after how many years?
This, Your Lordship, was filed.
Because that complaint apparently looks like after a year.
And this was filed.
Maybe what is the complaint date? Because the order of the Lok Adalat is 13.
Complaint was is
2000.
2015.
Huh?
The CR case is 1161 of 15.
15. No, that is the
Yes,
yeah.
sir.
That is the negotiable instrument
Yes,
case,
madam.
correct?
Yes,
In which the matter was finally concluded on 13/2/16,
yes, madam.
the settlement,
Yes,
isn't it?
yes, madam.
Now, after this, next date,
Next date, my lord, for the.
when did you said that you did
Yes,
file
our,
a FIR?
we had submitted an application on 12/9/2017,
12,
9/2017.
9, 2017 for what?
At page 48, my lord,
Yes.
wherein we had stated that, my lord, we were coerced
Acha.
by misrepresentation of
Okay,
actual
so this
facts,
came after almost more than a year.
more than a year.
Okay. And finally, when did the writ petition file?
Writ petition was filed, my lord, we had moved it on.
File,
File 24/11/2017, it was moved.
24,
11/17, it was moved, my lord.
2017, moved or filed?
Filing date, I'll just check.
So around that time,
Yeah.
Yes. Because affidavit shows November 17.
November
17.
17. Okay. Yes, continue, Mr. Mohanta. Having obtained the award,
Yes, Your Lordship.
having obtained the award from Lok Adalat,
The para 16 I was reading. Your Lordship.
yes, having from that part, you
Yes, sir.
just read that now after more than 3 years raising such plea is untenable, read thereafter.
The parties,
It's just below page 57.
yes, Your Lordship. Having settled the matter in Lok Adalat, and now after more than 3 years, raising such plea is untenable. Having obtained the award from Lok Adalat, the party is not permitted to resile from the same. It attains finality to the dispute between the parties finally and binds all. Therefore, the order in this regard needs no interference. Next, once the parties enter into compromise before the Lok Adalat, and at that time no question of any pecuniary jurisdiction was raised and oblique or required to be considered by the Lok Adalat, therefore, once the award is passed, it is executable under CPC. Next, Your Lordship, para 17. In Valarmathi Oil Industries versus Saradhi Ginning Factory, the admitted facts were that CC number so-and-so was taken on file by the learned judicial magistrate number so-and-so on the complaint given by the respondent therein that a check was issued by the second petitioner thereon on behalf of the first petitioner as a partner of the firm. However, the same was dishonored by the bank due to insufficient funds. According to the respondent, after issuance of the legal notice to the petitioner, the complaint was given under section 138 of the NI Act against the petitioners during the pendency of the criminal case at the request of both the parties. The matter was referred to the Lok Adalat for settlement. Both the parties were present before the Lok Adalat, and as per the award, they agreed for the settlement, and accordingly, the accused petitioners agreed to pay rupees 3,75,000 to the respondent on or before 3/9/2007. It was signed by the respondent complainant, the accused petitioners, and their respective counsel. In view of the compromise arrived at between both the parties, the amount payable was fixed at rupees.
So this this one is signed by them.
Yes, Your Lordship.
Where do I get the signature? In page 34.
Yes, page 30, page 36 is the petition.
39.
39. Yes. The Assamese copy is page 13. The compromise petition.
38 it starts. huh?
38 it starts.
And signatures. This was signed of the same date, 13.
Yes. On next page, Your Lordship. 39, Gusoria Badi, Assami Vibadi. After going through the terms and conditions, I put my signature.
This is not translated copy, is not available.
It's there, my lord, page 36.
Page, yes, page 36.
Yes. Here, Mr. Khan, you are Mridul Rajkua and
Midul Rajpal and Seema Rajpal.
They put the signatures along with the date. Subsequently, page 40, I think they deposited some amount of money also. 2 lakhs after
Where do I get that?
page 40.
2 lakhs.
Yes,
That is the first installment.
yes, Your Lordship. So they have agreed to it. Subsequently, it was an afterthought.
Yes. Where do I get that first installment?
Page 40, Annexure 5, order dated 37/16. Middle part, Your Lordship.
Yes.
There, Your Lordship, complaint is absent. Order dated 37/16, Lordship is found. Annexure 5, page 40.
Yes.
Middle part, complaint is absent with step, white petition number so and so, heard peruse, allowed. Accused persons are present and white petition number so and so.
I've deposited.
Yes, Your Lordship.
8/6 also coming.
Yes, Your Lordship.
So and so the
Yes.
check bearing worth 1 lakh be given to complainant with receipt of acknowledgement.
Yes, Your Lordship.
So some money has been paid.
Yes. So intention of that, there was some
Okay.
correlation.
Yes, complete this sentence.
I was reading para 18, Your Lordship.
Yes.
When the said award in Valamarthi case was placed before the learned judicial magistrate by a judgment dated 17/10, Lordship got it? 17/10/2007, based on the award, he held that the petitioners therein guilty and convicted them under section 130 of the NI Act, accordingly imposed sentence of 1 year simple imprisonment and directed the petitioners therein to pay a sum of rupees 3,75,000 as compensation to the respondent.
Yes.
Agreed by which the accused petitioners preferred an appeal in CS number 167 of 2007 before the Session Judge Salem. The learned Session Judge, while suspending the sentence of imprisonment till 16/12/7, directed the accused petitioners to deposit the sum of rupees 3,75,000 before a trial court and clarified that in case of failure of depositing the amount, the order of suspension of sentence would stand cancelled automatically, and the petitioners were also directed to execute a bond for rupees 10,000 with 2 sheets.
But in this case, the present case,
Yes, Your Lordship.
is it under the writ petition? No.
A writ petition, my lord.
No. I'm talking about the
Or does
case,
this-
No.
the cited case.
No. This with regard to, can this court, like after an order has been passed by?
No, that is in
Yeah.
reference
Yeah.
to a appeal,
Yes, yes,
because that section says
yes,
no appeal.
Yes.
However, in a given, I am with you
Yes.
on merit
right,
that,
Yes, yes.
there has been a long delay.
yes,
And it appears it's an afterthought. That's a different thing. But to say that it is not maintainable, this decision may not be sufficient because this decision doesn't talk about a writ proceeding. Now, he is before a writ proceeding.
yes, Your Lordship.
226 is different.
To that regard, my lord,
So whether a 226 petition is maintainable or not, you have to show me that
Yes.
because I have understood that once it is
2018-3.
finalized,
Yes, Your Lordship.
and it will be a final decree and it is not appealable. Correct?
Yes, Your
That
Lordship.
is what you
Yes.
are showing, and these
Right.
decisions are all to that effect.
Yes. And Lordship, what is Lordship put me this question on the mental to read?
Hmm.
That judgment, Lordship, I just need to obtain it.
You have it.
Just take it out. 2018-13 is not it.
You find that,
Yes.
but Mr. Khan, anything you show, because I'm not,
writ is maintainable, my lord,
forget writ maintainability, even if suppose assuming writ is maintainable.
because
For 1 year, you were sitting, you made the initial 20 lakhs and suddenly after you are not being able to make the payment, you changed your mind and
No, because
you
I'll-
filed an FIR, you say, no, this is by coercion.
because
Sorry,
It
Mr.
was all-
Town, it doesn't inspire confidence.
it was all throughout,
This is a petition which is liable to be dismissed with heavy cost.
it was all throughout, my lord, my pleadings before this court and
Where?
in this court.
After, Mr. Khan, when? In 2017, November?
That is-
Settlement,
but the-
settlement was in February 2016.
But the process.
And and you have made payments after that? You have you have settled, you have signed in the settlement agreement, you have specifically said that you have not been given any threat. You keep quiet on the next date fixed, first installment, you pay, you don't make any grievance, you don't say anything. After that also you paid a check of 1 lakh. Thereafter, when you're not being able to make the payment, suddenly you realize, and just before filing the writ petition, you file an application in the month of September 2017 that you have been coerced. And in November 2017, you file a writ petition.
My lord, the fact remains is that section 20 of the Legal Service Authority Act has to be followed.
Mr. Khan,
Because,
you are not,
because in
I'm
the,
sorry.
in the affidavit in opposition which they have filed, they have not enclosed any document to show whether they have submitted an application before the court. Because section 20 says the parties have to agree.
All right, noted. I will deal with that
Then,
submission.
my lord, they have to make an application. That is also-
Anything else?
Third, my lord, the court has to be prima facie satisfied.
Anything else?
That is whether there is a
Section
chance of
20, I have
settlement.
understood. Anything else?
Because the court, in this present case at hand, the court has not, there is no
Mr.
order.
Khan, you have not objected all this. You have never objected.
Fourthly, my
I'm
lord,
telling you, this is a writ jurisdiction.
Yes, my
Your
lord.
conduct is of utmost important. This
fourthly,
court is not with you in conduct. You want heavy cost? Go for it.
fourthly, my lord,
Go for it. I'm telling you.
the
Your
reasonable,
conduct is not satisfactory.
reasonable opportunity,
Had you come immediately? Certainly,
That is-
Mr. Khan. Certainly. Had you come immediately? Certainly.
but
If you would have not paid the installment immediately after the settlement, you would have filed an FIR, you would have come before this court. This court would have certainly given you the protection.
with the
What's
background,
this? After 1 year, more than a year.
background facts, my lord, is that
Sorry,
the petitioner had taken a loan.
you are now at your risk.
One thing I need to show you, my lord, there is a judgment which I have annexed in my affidavit in reply of the apex court at page 90.
Yes.
It starts from page 90. The relevant para is at page 91. It says cognizance of cases by Lok Adalat. Then para 7 at page 92.
Yes.
This specific language used in subsection 3 of section 20 makes it clear that Lok Adalat can dispose of a matter by way of compromise or settlement between the parties. Two crucial terms in subsection 3 and 5 of section 20 are compromise and settlement. The former expression means settlement of differences by mutual concession. It is an agreement reached by adjustment of conflicting or opposing claims by reciprocal modification of demand. As per the term so and so, a compromise is a mutual compromise of two or more parties that are at controversy. As per Bouvier, it is an agreement between two or more persons who, to avoid a lawsuit, amicably settle the difference on such terms as they agreed upon. The word compromise implies some element of accommodation on each side. It is not apt to describe a total surrender. This is important, my lord. What I am saying so is that
Had you immediately come?
that I have not
Yes.
come, but the fact remains is that there is a total
The
surrender. on my
decision
part.
of the apex code is contextual.
No.
It is contextual. It is given in the context of each case. This decision does not fit in the context of your case, Mr. Khan. I'm
Because
sorry.
the amount was of 4 lakhs, the check amount, the amount in the prayer was for 8 lakhs, and the agreement was for 8
You got
lakhs.
that decision?
Yes, sir.
Agreement was for 8 lakhs. There was total surrender on my part, my lord. Although, and in my petition, my lord,
Could have come earlier, maybe.
because my lord,
See,
why?
Mr. Khan, I'm repeating myself. This is a writ extraordinary jurisdiction that you are before. Your conduct is of utmost importance.
Because para 6 of my petition may also be.
In
also
earlier
be seen.
hearings also the same question came up, your lordship. If your lordship will see the
Paragraph. Huh?
the tab is.
Paragraph. Just highlight the paragraph.
Yes.
You have the pen here.
Yes, sir.
Highlight it. Yes, you
And-
can conclude your arguments.
And there were no proper legal, there was advice to him at that point of time, because in my petition, I have specifically stated, my lord, they had taken a loan from the private respondent for his daughter's treatment. His daughter unfortunately passed away.
All right, next argument.
And secondly, my lord, when the notice, because my lord may kindly, because that goes to the root of the matter, section 20.
That you have, how,
Yes.
there's no point of repeating it,
Yes, my
Mr.
lord.
Khan.
Because, my lord, I'm arguing about section 20 of the act.
Provided your conduct was such that this court would have given you the indulge. Now, if the court has taken a view of your conduct, whatever be it, this court will not exercise its discretion in your favor. This is why I'm repeatedly saying, this is a writ petition. This court is not, this court is not inspired with your conduct. You have initially deposited.
2 lakhs
You-
I have deposited.
Correct. And 1 lakh check also you have given. You keep quiet.
No,
You keep
1 lakh was prior
quiet
to
for
that.
more than one, anyway, let us say 2 lakhs.
2 lakhs, sir.
After that, you keep waiting. 1 year later, and you failed in your installments, and then after 1 year later, you file an application that you have been coerced, and immediately after 2 months, you come and file the writ petition. You ask yourself,
No,
you ask yourself
I-
this
my-
question, Mr.
I-
Khan,
I'm-
you're an officer of the court.
I'm putting myself.
You
into
are an
the-
officer of the
I'm
court.
putting myself in the position of my petitioner, my lord. They were not properly, I may say.
That cannot be, they
advised,
are
properly
assumed
advised,
to
my
know the law. No, ignorance cannot be
That I'm-
pleaded in this
Because, my lord-
fashion. Sorry, Mr. Khan.
And in my, one. more-
Yes,
Para 25 and 26. It says it can be done, but on a very limited ground where the decree has been passed without the consent of the parties.
Para,
Para 25 starts. It cannot be marked here also because it's the online thing. It cannot be marked.
Oh.
There. Para 25 and 26.
the High Court dismissed the writ petition, holding it not to be not maintainable. The aggrieved party therefore filed an appeal by way of special leave before this court. This court, after examining the scheme of the act, allowed the appeal and set aside the order of the High Court. This court held that the High Court was not right in dismissing the writ petition as not maintainable. It was held that the only remedy available with the aggrieved person was to challenge the award of the Lok Adalat by filing a writ petition under Article 226 and 227 of the Constitution, and that too on very limited grounds.
Yes, sir.
The case was accordingly remanded and so and so. It is true that when an award is made by the Lok Adalat in terms of a settlement arrived at between the parties, which is duly signed by parties and annexed to the award of the Lok Adalat, it becomes final and binding on the parties to the settlement and becomes executable as if it is a decree of a civil court, and no appeal lies against it to any court. If any party wants to challenge such an award based on settlement, it can be done only by filing a petition under Article 226 and 227, that too on very limited grounds. But where no compromise or settlement is signed by the parties and the order of the Lok Adalat does not refer to any settlement, but directs the respondent to either make payment if it agrees to the order or approach for so-and-so, it does not agree, is not an award of so-and-so. The question of challenging such an award in a petition does not arise. As already noted, the instruction will have to be heard and disposed of the appeal. Yes. All right, take down. Heard Mr. S. Kaun, learned counsel appearing for the petitioner. Also heard Mr. K. M. Mohanta, learned counsel appearing for the
Respond number 3 and 4.
respondent number 3 and 4. What about 1 and 2?
Notice has been served.
Notice have been served, they have not appeared, my lord. As per office note dated 30/12/2019.
Office note dated
30/12/2019.
30/12/19. Pertinent that though notices have been duly served upon the respondent numbers 1 and 2 as apparent from the office note dated 30/12/19. There has been no representation on behalf of the aforesaid two respondents. The writ petition um, the pleadings having been completed, the writ petition is taken up for final disposal at the admission stage. This has come for admission, not today.
Yes, sir.
By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the award dated 13/2/2016, passed in the Lok Adalat conducted by the District Legal Service Authority, Nagaon, in connection with CR case number 1161 of 2015, which was posted in the court, that is not required, which was posted in the court of Munsif cum Judicial Magistrate First Class Hojai, Nagaon. Just one second. Mr. Sharma? Yes. No, since you are sitting, most likely in that matter of yours, that draft is ready. But I couldn't have time to read, so I'll reserve it. It's better to reserve it. It'll take some time for the final conclusion. So you may not wait. You are there? All right. One number? 20? In item 20, Pranab Belake Likhiloba, that episode Namkhini Didiba Upper. Hearing is concluded, reserved for judgment. Huh?
I'm good.
You have given some records, no?
No, sir, yes,
Those records pertains to?
pertains to this tended document.
Episode that, all right.
No, sir.
I'm just, because since you are,
No, sir.
otherwise you'd be only unnecessarily sitting. You're most welcome to sit here unless you don't
No.
have anything. Yes. Hmm. The brief facts of the case is that where do I get the facts? Yes, I think is it para 3, Mr.
Yeah.
Khan?
Para 3, I have, yes, madam.
Not
Case-
go into so much detail.
Case was, para 4 is the complaint case, madam.
That case was after the this money was not being able to pay, right?
Yes, madam.
All right. And that complaint case is where at page you had shown me
Page 17. Oh,
17. Okay. Just hear out, okay? Is that in the year 2004, the daughter, the petitioner number 1, who was the petitioner number 1 had borrowed money from respondent number 4,
yes.
from the respondent number 4. And in connection of the aforesaid loan, the petitioner had issued certain check, which upon being dishonored, a complaint case was filed, being CR number 1161 of 2015. By the complainant stroke respondent number. Complainant Kanak Paul is you.
Yes, sir.
Respondent number,
3 and 4.
huh?
Complainant respondent 3 madam.
3, na?
Yes.
Stroke respondent number 3.
Number 3.
Against the petitioner number 1
And 2.
and 2. Under section 138 of NI Act 1881, read with section 142 of the said act as amended up to date before the court of
Before the court of Sankadev Nagar, Nagar.
Hmm?
Report of Sankadev, before the court of judicial magistrate at Sankadev Nagar, Hujai.
Paisa. Before the court of, it is not clearly given here.
Court of judicial magistrate first class, Hujai.
Judicial magistrate first
First
class
class.
हो जाए,
Hujai.
ठीक है? In the aforesaid complaint case, both the parties appeared through their respective counsels.
No, we never appeared before the court. What has happened in this case?
No,
my lord?
factual, I'm saying.
Yeah, no, actually, we never appeared before. the
No,
court.
in these orders, it says you have appeared, not appeared.
Not appear, my lord, because the initial deposition was never taken. Straight
Uh,
away, the matter.
All right, all right. In the said complaint case, by order dated 13/2/2016, when the case record was put up before the National Lok Adalat, of which notices were sent to both the parties, including the petitioners as well as the complainant. And upon the parties having, and upon the parties appearing before the National Lok Adalat on the scheduled date, and in terms of the amicable settlement arrived between the parties, the National Lok Adalat, by order dated 13/2/2016, disposed of the case in terms of such settlement arrived between the party. It is the specific case of the writ petitioner that, which is that paragraph you said coercion? You were reading out to me paragraph?
Yes, my lord.
Para 6, your lordship.
Para 6?
Yes.
It is the specific case of the writ petitioner that the writ petitioner was though the writ petitioner was reluctant to appear before the Lok Adalat on 13/2/2016, however, due to the threat given by the respondent number 4 stroke, is respondent number 4 a petitioner here? not a
Yes.
petitioner.
Respondent number 4 is the husband.
Husband is the petitioner. R four.
Stroke, respondent number 4, due to the threaten given by the respondent number 4, the petitioner had to appear, had to attend the Lok Adalat and sign the compromise deed, which was, and sign the compromise deed. Stop. Situated thus, the present writ petition has been filed. Next para. Mr. So-and-so Khaun, learned counsel for the petitioner, submits that the petitioner has been coerced and has been coerced to sign the settlement compromise deed before the Lok Adalat, and therefore the order of the Lok Adalat impugned in this writ proceeding is illegal and void ab initio. He further submits that the procedure contained in Section 20 of the Legal Services Authorities Act 1987 has not been followed, for which the impugned order of the Lok Adalat warrants interference from this court under Article 226 of the Constitution of India. Right, these were the main two arguments of yours.
Yes, my lord.
Per contra, Mr. Mohanta, learned counsel for the petitioner, respondent numbers
3 and 4.
3 and 4, submits that the writ petition is not maintainable inasmuch as the order impugned of the order passed by the Lok Adalat impugned in this writ proceeding have been passed on the basis of the amicable settlement arrived between the two parties. He further submits that under Section 21 of the So-and-so Act, every award made by a Lok Adalat is final and binding on all the parties to the dispute. In support of the aforesaid submission, he relies upon the decision of the apex court in the case of K.N. Govindan Kutti Menon versus C.D. Saji, reported in 2012, volume 2 SSC at page 51. He further submits that the contention of the learned, the argument, don't say argument, the allegation of the respondent number 4 coercing the writ petitioner to appear before the Lok Adalat and sign the subject settlement deed is unbelievable, inasmuch as pursuant to the settlement, the writ petitioner had already deposited the first installment of rupees 2 lakhs in terms of the award of the Lok Adalat. And it is only after more than a year that the writ petitioner has, for the first time, filed a complaint alleging coercion and has filed the instant writ petition. around November 2017. Stuff. Heard, perused, Didiba, and considered citations. Huh? It appears that in the subject complaint case, on 13/2/2016, the case record was put up before the National Lok Adalat, wherein the complainant stroke respondent number 3 and 3
Yes.
and the accused person stroke petitioner, only one petitioner, two petitioner, petitioner number 1 and 2 were present in pursuance of the notices issued to the parties. The order dated 13/2/2016 of the Lok Adalat reads as under, quote unquote. Page 33, Baba. Reading of the aforesaid order, it appears that in view of the amicable settlement arrived between the parties in accordance as per the terms and conditions mentioned in the compromise deed, the case was disposed of by the Lok Adalat vide the aforesaid order. Apt to refer to the compromise deed, which reads as hereunder. Compromise deed dated 13/2/2016, which reads as hereunder. A2A, page 36. Reading of the aforesaid compromise deed, it appears that both the parties, i.e., the writ petitioners as well as the respondent number 3 and 4 stroke complainant, were present before the Lok Adalat on 13/2/2016, and none of the parties has put threat or pressure on each other to come to the settlement, and that both the parties have settled the matter in the court amicably. The aforesaid compromise deed is signed by the complainant stroke respondent number 3. Only 3 has signed or 4 has signed?
Yes, no, only 3.
3 and the writ petitioner stroke accused. It further appears that the terms and conditions clearly, it further appears that both the parties have agreed that in terms of the demand made by the by the complainant stroke respondent number 3, the two accused persons stroke writ petitioners has agreed to pay the amount of rupees 8 lakhs in 4 equal installments, i.e. rupees 2 lakh per installment to the complainant with interest as per annual interest rate fixed by banks from first week of the month of June. It further appears that the respondent number 3, complainant, has also accepted the said terms and conditions in sound health and mind and accordingly withdrawn the case on compromise. It appears that thereafter, when the case record was put up before the jurisdictional, this is a magistrate, Munsif court, na? Jurisdictional Munsif court,
This is a judicial magistrate, right?
judicial magistrate court. On third, comma, the court of magistrate, the jurisdictional magistrate court by after perusing the order of the Lok Adalat and being satisfied that the parties have settled their disputes amicably as per the terms and condition by order dated 13/2/2016 fixed 8/6/2016 for payment. It appears that on 8/6/2016, since both the parties were absent without steps, the matter was fixed on 30/7/2016 for necessary order. Order dated 30/7/2016 passed by the jurisdictional magistrate reads as under, quote unquote, page 40. Reading of the aforesaid order, it is clear that in terms of the settlement arrived between the parties and as per the award of the Lok Adalat, comma, the writ petitioner deposited a check bearing number 472473 of rupees 2 lakhs as the first installment as the first installment one second. In 37, did I say? In 37, you say, reading of the so and so, it appeared that though complainant was absent, however, the writ petitioner stroke accused persons were present and deposited. ठीक है, sir? Correct?
Yes, yes, Your Lordship.
So and so. ठीक है? It appears that thereafter on 8/8/2016, the complainant was present before the Court of Jurisdictional Magistrate, and on that date, he received the check bearing a check of rupees 2 lakhs, which was deposited by the writ petitioners stroke petitioners. Accused person. It further appears that after the aforesaid first installment, no further payments were made by the writ petitioners stroke accused persons to the petitioner, to the complainant stroke respondent number 3 and 4.
Yes.
It appears that the complainant stroke respondent number 3 accordingly filed a petition before the jurisdictional magistrate, bringing to the notice of the jurisdictional magistrate court as regards the violation of the terms and condition of the award of the Lok Adalat by the writ petitioner stroke accused persons. It further appears that the jurisdictional magistrate court, by order dated 10/7/2017, after perusing the said petition filed by the respondent number 3 and 4 stroke complainant, issued notice to the writ petitioner stroke accused persons for appearing in the court by fixing 10/8/2017 for appearance. Stop. 10/8 is here, that order is here.
10/7.
Not 10/7, 10/8. I don't think that is given. Yes.
No, Your Worship, not given.
It appears that thereafter, on 12/9/2017, the writ petitioners stroke accused person filed, what is this file?
A petition, my lord.
Hmm?
Petition number 3877.
Wait, sorry, 1 second, huh? No, the document at page 46 is what?
This is the notice.
Notice to you.
Yes.
It appears that it appears that since the writ petitioners has not deposited the subsequent installments in terms of the award
13/2.
passed by the Lok Adalat, in terms of the terms and conditions of the compromise settlement deed, based on which the award of the Lok Adalat was passed. Notice was issued by on 12/9/2017 by the jurisdictional magistrate court to the writ petitioner to deposit the to appear in the court on 12/9/2017 and deposit the second installment, i 2 lakhs, failing which necessary order will be passed against him. Stop. A notice corner date which says 7/8/2017. There. ठीक है sir? Are fixing it 8/12/9. It appears that the writ petitioner, instead of appearing before the jurisdictional magistrate on the date fixed, all right, sorry. This, where is your complaint?
My complaint at page 48.
And where do I get the date?
Date is on the same day, my lord.
12/9.
Yes, my lord. Page
Okay.
50 is the order.
All right. Then you say, it further appears that on 12/9/2017, the accused persons stroke writ petitioners appeared before the jurisdictional magistrate and filed a petition bearing petition number 3877 seeking exemption from making further payment. It appears that no, the apt to refer to the order dated 12/9/2017 passed by the jurisdictional magistrate, which reads as hereunder A to A, page 50. Reading of the aforesaid order, it is clear that the jurisdictional magistrate, after perusing the aforesaid petition filed by the accused person stroke writ petitioner, disallowed the same as not maintainable in view of the case having already been disposed of on compromise before the National Lok Adalat on 13/2/2016. Stop. Apt to refer to the said petition, which reads as hereunder. This is the petition, na, at page 48.
Yes, sir.
A to A kore diba, huh? A petition dated 12/9/2017, huh? Reading of the aforesaid petition, it appears that the petitioner that the writ petitioner, this is petition number 1 or what the husband?
Husband is one.
That the petitioner number 1 was coerced and misrepresented and coerced by the respondent number 4, correct?
Yes.
To go with him to the jurisdictional magistrate court and sign the compromise deed without knowing that the amount is that the amount stated therein is 8 lakhs instead of the 2 lakhs. Correct?
Yes, sir.
This is what I think you have said.
Yes, sir.
It appears that thereafter, the jurisdictional magistrate, court of jurisdictional magistrate, on 23/10/2017, when both the parties were absent, including the writ petitioners stroke accused persons who were directed to make the payment on that date, was pleased to fix the matter on 23/11/2017 for making payment. It appears that the writ petitioners, instead of making the payment, are appearing before the court on the scheduled date fixed by the jurisdictional magistrate court, filed the instant writ petition on 2017, assailing the award of the Lok Adalat. The instant petition having been filed under Article 226 of the Constitution of India, seeking issuance of extraordinary writ jurisdiction, extraordinary writ, not jurisdiction, comma, the conduct of the petitioner assumes significance. What is striking in the face of the record is that the writ petitioners, both the accused persons, appeared before the National Lok Adalat on such and such date, after receiving the notices and have agreed and have agreed to make the payments as demanded by the respondent number 3 and 4 stroke complainant, which have been put in a compromise deed duly signed by the writ petitioners as well as the complainant. It further appears that after the said settlement stroke compromise and the matter being finally decided and based on which the Lok Adalat had passed the award, the writ petitioners stroke accused persons has also deposited the first installment before the jurisdictional magistrate court. It further appears that after making the first payment, first installment, the writ petitioners stroke accused persons stopped appearing before the jurisdictional magistrate court on the dates fixed for making subsequent payments. And after receiving the notice from the jurisdictional magistrate court almost after 1 year, no, almost October, for making the for depositing the second installment and appearance, the writ petitioners for the first time on that fixed date of appearance and for making payment filed a petition alleging coercion and threat being meted out, alleging threat being meted out to the writ petitioner number 1 by the husband of the by the respondent number 4, based on which he was coerced to put his signature in the memorandum of compromise deed. It further appears that after the aforesaid petition being rejected and the matter being fixed on another date for making payment, the petitioner, instead of making the payment, petitioners filed the instant writ petition, which is almost after more than, can you calculate which is approximate, which is almost after 1 year dash months from the date of the award passed by the Lok Adalat, i.e. on such and such date. It further appears that in the petition filed before the jurisdictional magistrate, wherein for the first time the petitioner number 1 had alleged coercion, there is no mention as regard under what circumstances the petitioner number 2 had put her signature in the compromise settlement deed. The argument of Mr. Khan, learned counsel appearing for the petitioner, that the award of the Lok Adalat is liable to be set aside as the same has been based, as the same is based on the memorandum of compromise arrived between the parties, wherein the accused, wherein the writ petitioners stroke accused were coerced to put their signature, is totally fallacious and cannot be accepted. It is but obvious that the petitioners, after failing to deposit the remaining installments in terms of the compromise deed, by way of an afterthought, has filed the petition wherein the allegation of coercion for the first time after expiry of after almost 1 year was made before the jurisdictional magistrate court. In fact, the averments made in this writ petition, wherein such ground of coercion is pleaded on oath, appears to be false statement made on oath. This court has no hesitation to hold that this writ petition is nothing but an abuse of the court process. And therefore, the writ petitioner is not entitled for any relief whatsoever from this writ court. Cost. Writ petition stands accordingly dismissed, no cost.
So they will make stay order operating, that may be.
Stay order to vacate Cordoba. I shall do some editing.
Obliged.
Sorry, Mr. Count. Yes,
May I please, Your Lordship? The instant appeals are basically on the order passed by the Ganesh Session Court, whereby the appellants were convicted under section 304 part B. And Your Lordship had gone to the evidence on the previous occasion, whereby total number of 22, 24 witnesses were examined.
it is beautiful. Mr. Mohanta, those that decision which you had given me from your iPad, please give a copy. Ask your junior to supply the copies. Yes, Mr. Das?
Yes, Your Lordship. Your Lordship had the occasion to go through the evidence of almost.
The offense is under section
Lordship, section 104 part B.
104 part B.
Part B, and also under Lordship, please, not 302, 104 part B and 149 Lordship.
149.
Lordship.
And the sentence?
The sentence was passed, Lordship, whereby the appellants were given imprisonment of 5 years, Lordship. 4
5
years,
years.
Lordship,
Huh?
rigorous imprisonment for 4 years, Lordship.
Arrive for 4.
4 years, and with simple imprisonment for 6 months each, Lordship.
304 part 2 is not there.
It's there, Lordship. 304 part 2 of the IPC.
So basically 148 and 304 part 2.
149 and 304 part 2, Lordship.
We'll have to start from the first.
Lordship.
I have forgotten.
Lordship.
Yes.
So, Lordship, if-
Being a criminal trial,
Lordship.
every time you read a paper book, you don't know what may come.
Lordship.
It's not necessary you may have the same perception which you had on the last occasion.
Lordship. I'll have please just go, Lordship. Lordship, if your Lordship takes, there are two.
Isn't it, Mr. Borua? Yes.
Lordship, now there are two appeals in this connecting matter, same subject matter.
Anything?
Yes, I can tell.
Part third, that is also, I think, part third. Item 10.
What happened?
Item 10. I have told him to, this part thirds will have to be called out now serially. So, it will be called. Unless you have any difficulty, then you may say, otherwise it will be called after, as per the sequence of part third. Before any other hearing is taken. Yes.
Lordship. So, Lordship, there are two connected criminal appeals, Criminal Appeal 179 of 2011 and Criminal Appeal 169 of 2011. So,
Criminal appeal 179 and 169, right?
69 of 2011, Lordship.
Yes.
And there are total number of five appellants in Criminal Appeal 179.
In 179 total 5.
5 appellants, Lordship. If I may name them, Lordship.
1 second. Where do I get their names? Then it will be easier for me. So basically, I will use this paper book only. One paper book only, isn't it?
Lordship, one paper.
Where do I get their names? Then it will be easier for us to. The names of the accused, the
Lordship, we
paper
can
book.
peruse the impugned judgment will contain all the accused person's name, Lordship. Impugned judgment will,
It is here at the index, isn't it?
Yes.
yes, but
313 examination.
313, yes, your Lordship.
So Jadumani Kumar is
Is Lordship appellant number 2 in Criminal Appeal 169 of 2011.
in 169. And then
Then in similar 169, Lordship, appellant number 1, Vikas Changmai.
appellant 1.
Yes, your Lordship.
Then
Appellant number 3, Babu Changmai.
169.
Yes, Lordship. 3 appellants in 169.
All right. Then
And in Criminal Appeal 179, Lordship, appellant number 1 is Ananta Changmai. Ananta Changmai.
where do I get his name?
Lordship, that if your Lordship produces the paper book, that is in
Yes,
the fourth-
Ananta.
fourth page.
Yes, I got it.
yes, Lordship.
He's 1.
He is appellant number 1, Lordship.
179, right?
Lordship.
Yes.
And appellant number 2 is Sanjit Changmai. Sanjeev Changmai, Lordship, that
Uh-huh.
is Sanjeev Changmai.
Okay.
If your Lordship peruses the fourth row from the index after Ananta Changmai, Sanjeev Changmai.
Yes, but he's on sentence. Why his 313 has gone? He was not 313 examination not done.
Done, Lordship.
Okay.
Lordship, statement of Ananta Changmai.
All right, anyway.
Yes.
I'll put it here only.
Lordship.
He is accused number
Sanjeev Changmai is appellant number 2,
2 in
Lordship.
179.
Lordship.
Then,
Comes Latu Changmai, Lordship.
yes,
He is appellant number
Master?
3.
you come when we call you. Otherwise, your sequence unnecessarily gets disturbed. Sorry, accused number 3 is
Latu Changmai, Lordship.
Latul. Where do I get? Yes, I got him.
Lordship.
A3.
3, Lordship.
Yes,
Appellant number 4 is Ranjan Changmai, Lordship.
Ranjan.
Immediately after Ananta Changmai, Lordship.
Yes, A4.
Lordship.
Yes.
Then comes Tarun Changmai, Lordship.
A5.
These are the appellants, Lordship. This piece, Lordship.
Yes.
Lordship. Now, a total number of Lordship, 20 witnesses were examined on behalf of the 24 Lordship.
24, I think.
24 Lordship on
Yes.
behalf of the prosecution, Lordship.
Yes.
And Lordship, out of that Lordship, basically PW 4, 5, 10, 13, 16, 11, and 23, they had all given general statements with regard to the incident.
General.
Yes, Your Lordship.
4.
4, 5, 10,
Yes.
13,
Yes.
16,
Yes.
11, and 23, Lordship.
Yes. These
Lord-
are all general.
General statements, Lordship. Now, if your Lordship comes to PW 1, Lordship, Chandra Buradahai.
23 IO.
I,
Huh?
23 is the IO.
23 is the IO.
yes, Your Lordship.
Okay. Yes. Mr. Bhattacharya, take your seat.
Yes, ma'am.
I think Mr. Das is going to take some time
will take.
because he has to present everything. Yes.
Lordship, Lordship, now if I may read the deposition of PW 1. I know accused Ananta Changmai, Saso Changmai, Ranjan Changmai.
One sec, before you go there, where is the FIR?
The FIR, Lordship. The FIR will be at page 1, Lordship, of the paper book, Lordship.
Page 4 start.
Yes,
Shall we read from page 4?
Lordship. Humble submission is that around 10:30 a.m. on 7/3/2004, the below mentioned accused persons, along with others, assaulted my brother Shri Nathu Buragohai on his head and various parts of his body with dowel, sticks, etc., and thus caused grievous injury to him. I immediately admitted my brother in Sibsagar Civil Hospital at around 9:30 a.m. today. That is on 8/3/2004. My brother died. That the lodging of the Ezahar got delayed as I was busy with my brother's treatment. So this is the names of the accused persons were initially, Lordship, Tarun Changmai, Saso Changmai, and Latu Changmai, Lordship. One, that is, if your Lordship sees, in criminal appeal 179, appellant number 3 was named. Thereafter, appellant number 1, Saso Changmai is also known as Ananta Changmai, appellant number 1, Lordship. And Tarun Changmai is, Lordship, appellant number 5. These were the 3 accused who were named in the FIR.
Tarun is accused A.
Tarun Changmai is appellant number 5, Lordship, in 179, Lordship. Saso alias Ananta Changmai is appellant number 1.
179.
Yes, Your Lordship.
And Latu.
And Latu is appellant number 3, is same appellant 179, Lordship.
Okay.
So these were the only 3 people who were named, Lordship.
Yes.
Now, Lordship, if your Lordship peruses comes to page 10,
And
Lordship.
the informant is the brother, na?
Brother, Lordship, because the accused
Brother.
person
And he's PW
is PW 1, Lordship. Chandra Buragohai,
1.
1.
Yes.
Lordship. I know accused Ananta Changmai, Saso Changmai, Ranjan Changmai, Babu Changmai, Sanjeev Changmai, Latu Changmai, Vikas Changmai, and Jodumoni Kuar were present in the court. Deceased Nathu Buragohai was my brother, and the accused persons I have mentioned today assaulted him to death. The incident took place about 3 years back, the day I went to Sibsagar town to do shopping. I returned home from Sibsagar town at around 2:30 p.m.
My mother, Punidoy Buragohai, told me about the incident that accused Saso alias Ananta and Sanjeev Changmai tied Nathu and took him to Karigaon. Then I went to Charaguri. I did not get any clue there. When I reached near Namgarh, a prayer hall used by Vaishnavite Hindus in Assam, at Karigaon, I asked the person and he told that the police had arrested a boy from there. I came to Sibsagar police station therefrom and came to know that Nathu Buragohai was taken to the civil hospital. I found Nathu in the civil hospital while he was undergoing treatment. I saw bleeding injury on Nathu's head. When I asked Nathu, he told me that Sanjeev Changmai, Ananta Changmai, Tarun Changmai, Babu Changmai, Vikas Changmai, Jodumani Changmai, Ranjan Changmai, and another person assaulted him with rod and stick. The sun was about to set when I reached the hospital. I was at the hospital till about 9
Who
p.m.
said this guy, what is his name? Who said when I asked Nathu?
It's the victim himself who, as per the position
Victim
of,
has given statement.
no lordship. This is the statement of the which has been brought out only during the evidence by the prosecution.
PW1.
Yes, your lordship. That there has been a statement which was made in the hospital by the deceased.
So this is no, he's not examined.
No lordship, because he already expired
He
lordship.
expired.
Yes, your
after that.
lordship. And moreover, this is a story lordship which has been brought forth later.
When did he expire?
He expired on lordship on that very same day after he was admitted.
On 8/3/2004.
8/3/2000. Yes, lordship. 8/3/2004, lordship. His brother died, as per the FIR.
Yes.
Now, and stick. The sun was about to set when I reached the hospital. I was at the hospital till about 9 p.m. Subsequent to my arrival there, Nathu became speechless at about 7 p.m. I came home around 9 p.m. Nathu died around 9 a.m. in the morning. After Nathu's death, I lodged an Ezahar with the police station. Exhibit 1 is the Ezahar. Exhibit 1-1 is my signature. Police held inquest on the dead body. Exhibit 2 is the inquest report. Exhibit 2-1 is my signature. After the postmortem examination, the body was handed over to me. Police came to the place of occurrence. The police seized the shirt, pant which were in the wearing of the deceased. Exhibit 3 is the Caesar list. Exhibit 3-1 is my signature. Police recorded my statement. Police seized the gamusa, a traditional hand-woven towel, and a bamboo stick from the place of occurrence. I do not know why the accused persons killed Nathu. My mother, during cross lordship, my mother, Punidoy Buragohai, is still alive. I live at village Gorkhush.
Mother is examined.
Mother, Punidoy Buragohai, has not been examined, lordship, in this case. My mother, Punidoy Buragohai, is still alive. I live at village Gorkhush. I was living separately from Nathu. Village Loraputa can be reached from village Gorkhush via Naujan. I heard that the incident took place at village Gorkhush. The said village is about 3 kilometers away. I know Nalia and he is from Naujan. There was a wedding. Now Nalia is the deceased lordship here in this case. Sorry, not the deceased. There was a wedding in his house, lordship. He is the Nalia. The day before the incident, I saw only one blood injury on Nathu's head in the hospital. I only mentioned the names of accused Tarun Saso, alias Ananta, and Babu Changma in the Ezahar. Exhibit 1. I knew the name of the accused from the deceased before the Ezahar was lodged. Bimal Buragohai was with me when I went to the hospital and talked to the deceased. Bimal is still alive. Later, police questioned me during the investigation. It is not a fact that I did not tell the police that deceased Nathu had told me the names of the accused persons who assaulted him.
Does PW20 corroborate about the deceased telling?
He has stated that deceased has stated some names, but the names differs because some of the names were excluded, lordship.
Because that perhaps would also be a question whether this could be a dying declaration. Mr.
No,
Bhattar?
lordship. That won't come under dying declaration, lordship.
Yes.
Lordship. It is not a fact that I did not tell the police that deceased Nathu had told me the names of the accused persons who assaulted him. It is not a fact that I told the police that Tarun Changmai, Saso Changmai, Latu Changmai of village Charaguri, along with some others, took Nathu to Karigaon and admitted him into the hospital for his treatment. It is not a fact that I told the police the names of some Vishnu Saikya, Rantu Changmai, Diti Changmai. It is not a fact that Nathu did not tell me the name of any accused persons prior to his death. I did not witness the incident. It is not a fact that neither I mentioned in the Ezahar nor did I tell the police that I heard about the incident from my mother Punidoy. The distance between Loraputa and Karigaon by road is about 6 kilometers and across the field.
it is about 4 kilometers. It is a fact that I did not mention in the Ezahar as to where from I knew about the incident. I do not know if accused Tarun Changmai is blind. It is not a fact that I did not have a good relation with the deceased. The people of Loraputta do civilization on the grazing land and lives there. The Darika River separates Loraputta from Naujan. It is not a fact that deceased Nathu Buragohai forcibly enters the houses of people of Loraputta, and when the women see him, they shut the door. It is not a fact that when Nathu had committed untoward incident at the wedding of Nalia's daughter, the people present at the wedding kept him tied. It is not a fact that Nathu was tied and assaulted at Nalia's house at night and was released in the morning. The house of the accused persons, except the house of Saso, are situated at Karigaon. It is not a fact that the accused person did not assault deceased Nathu Buragohai. I had not seen deceased Nathu at the home on the day of occurrence. It is not a fact that the deceased did not reside in the house at all. A bloodstained shirt and a bloodstained white vest were seized from the body of the deceased to Exhibit 3, Material Exhibit 1 is the bloodstained check shirt. Material Exhibit 2 is the bloodstained white vest. So this is the deposition of the informant, Lordship. If I can point out a few contradictions here, Lordship, that is one which your Lordship will find later on with the other person who accompanied him to the hospital, who stated that, yes, he did state some names, but not all the names were stated. So there's a discrepancy in that. Moreover, Lordship, this fact has to be considered that he knew about, if we go by his statement, he knew of all the accused person's name before lodging of the FIR. And when the Ezahar was lodged, the FIR was lodged, specific names of only 3 were attributed, Lordship, and not the others, Lordship.
Because if you have to believe this part,
If we have to believe this part, Lordship.
whose names he had mentioned?
Lordship,
Sanjeev, Ananta, Torun, Babu, Vikas, so all names.
yes, your Lordship.
He mentions all the names.
All the names, all the appellants here, Lordship. But in the FIR, he mentions only 3 names, Lordship.
Yes. In the FIR, it was A.
FIR, he named only, Lordship, appellant number Tarun Changmai, Saso, that is appellant number 5, appellant number 1, and appellant number 3.
Tarun is 1 and then
Tarun is 5, appellant number 5, Lordship.
yes, and
Then Latu Changmai is appellant number 3.
one sec, I'm just making a round here. Latu is there this time? No.
In the appeal, he is there, Lordship.
No, in PW1.
Yes, yes. He has mentioned all the appellants.
Where is Latu here?
Lordship, when I asked
And
Latu,
another person. I don't think Latu's name is mentioned. Sanjeev.
Latu's name is not mentioned.
Correct.
Yes. Yes.
And who is the other one?
And the other Ananta Changmai, Lordship. There is Saso Changmai alias Ananta. That is appellant number 1.
No, here in this Ananta is there.
Yes, Your Lordship.
So Latu is accused number?
Latu is appellant number 3, Lordship.
He is not mentioned.
Latu is not mentioned here, Lordship.
That is also strange.
Yes, Your Lordship.
Isn't it?
Yes, Your Lordship.
If you have to believe this.
Exactly, Lordship.
Instead of mentioning all their names, he mentioned one extra, which is not even disclosed to him by his
Brother, Lordship.
brother.
Yes, Your Lordship.
Yes. So from PW1, I think that is only coming that when he went to, because nothing else otherwise,
Nothing
isn't
else,
it?
Lordship.
About enmity or how it has started.
Exactly, Lordship.
He
Because
only
Lordship,
said
when
that he came home, his mother said,
yes,
and when he went for looking, he was told that some boys have hit him, and then he went to the hospital. In the
Exactly.
hospital, when he met his brother told him that these people assaulted him with rod and stick.
Lordship. And
Isn't it?
contrary to that, Lordship, when we proceed with the evidence, your Lordship will see, police had only seized, later on the prosecution went on to rely on a bamboo stick rather than an iron rod, which was supposed to be the alleged weapon. And moreover, Lordship, again, as your Lordship has aptly put it, Lordship, the motive, Lordship, the learned trial court below, while pronouncing the judgment, has made a point that prosecution failed to prove the motive. That is why 304B came. So there has been no motive which has been proved by the prosecution also here.
And what about overt act?
Lordship,
overt act.
No overt act, Lordship. No one
But,
has
what
done
about the unlawful assembly?
nothing,
That
Lordship.
there was meeting of minds.
No, Lordship. Nothing
Nothing.
has been proved in this case because
it?
only thing which has been proved is that they have been seen at one instance. Even the circumstantial change.
Seeing will not be, some meeting of mind must be shown, no?
Exactly.
Yes, from the evidences of the all the depositions, my lord, there are 24 witnesses. Here, my lord, as per the trial court's judgment, my lord, they only mention about, my lord, PW 9 as a eyewitness, my lord. But from the and my lord,
PW 9 is the eyewitness.
No, Lordship.
No.
that is, my
That was
lord,
wrong founded.
from the, my lord, judgment, trial court judgment, my lord, I have gone
But
through.
in reality,
And
not an
PW
eye.
9 only stated that he is the person, he is the witness, my lord, who showed that someone has assaulted the, my lord, deceased. Later on, he came to know that it was Ananta from others, my lord.
Only one.
One, PW 9.
And that also later on he came.
Later on, he came to know that
How
that
can you
person,
be an eyewitness?
eyewitness, yes. Otherwise, all eyewitnesses, my lord, although projected to be eyewitness, all eyewitnesses has, my lord, only show that the deceased was caught hold by all these accused persons, my lord, and thereafter, my lord, taken away to a particular place. Thereafter, he was assaulted, and ultimately, on the next day,
So
deceased
that
person
has
was
been said,
died.
that these people have caught, have caught him and have taken.
Yes,
That is coming.
that is correct.
Whether that is satisfactorily,
Because
whether it satisfies the condition precedent, because unlawful assembly, isn't
yes,
it? So some parameters are there,
yes, my
Lordship.
lord.
which is to be first.
Unlawful assembly, my lord. Otherwise, some offense was committed. That offense was that.
That's okay.
Yes, all those persons were at that point of time where they are.
Whether
were
at that
getting
time
money.
they all were armed, not armed, how they had taken. Because if suppose some people have taken later on, if there is nothing to show who has done what,
Overt was-
how can you that, because you see sometime at certain point,
Yes,
they may not share that same intention.
Yes, yes.
But some sharing of the intention has to be also there.
First, I will have to prove unlawful assembly, and in case of
Correct.
unlawful overt act is also, my lord, not at all. my
Not
lord,
required so
required,
much,
my lord.
but
Yes.
first you have to prove that,
Yes,
isn't it?
exactly.
So I'm just what is coming to my mind, I'm sharing with you, Mr. Botaku, so that
And my
you-
lord,
you-
and the common object of that
Correct,
unlawful assembly
correct,
is to commit.
correct.
offense.
because holding them and taking them may not mean,
Yes,
maybe they wanted to question him something.
yes.
There could be a doubt, you see.
Otherwise, my lord, all the witnesses, my lord, from the evidences of the prosecution witnesses, what here I have done, my lord, because PW 1, my lord, he is the informant. He named two persons, PW 12 and PW 1, my lord, and PW 20, who accompanied him that while the deceased person, my lord,
But that is strange because you see, while he lodges the FIR,
at that point only three names, my lord.
3 names out of which one name is not
Latu,
even told
yes,
to him.
yes,
Where did he got Latu's name?
Latu,
In his own deposition, he doesn't talk about Latu,
Latu, no,
but in FIR he writes Latu.
yes. Left by only three names, that too after declaration made by the deceased, my lord.
What about in his 161?
161, my lord,
You have a look.
yes, my lord.
You have a look. What is his statements in 161?
Yes,
Right.
But considering the fact that there was a suggestion in the cross-examination that you have not made such statement before the
So
investigating
perhaps
officer.
it is not there.
Yes, it's probably.
You see, if that is there, then too, it is more likely that he was never told.
Lordship,
Now, where did he got these names from then?
Lordship.
Where that's where which part in this
In his
Cross?
cross-examination, Lordship,
one AC2 comedy
Lordship, at the very last, Lordship, it is not a fact that I did not tell the police that deceased Nathu had told me the names of the accused persons who assaulted him.
Yes. Can we just read this cross again?
Yes, Your Lordship. My mother, Punidoy Buragohai, is still alive. I live at village Gorkush. I was living separately from Nathu. Village Loraputa can be reached from village Gorkush via Naujan. I heard the incident took place at village Gorkush. The said village is about 3 kilometers away. I know Nalia and he is from Naujan. There was a wedding ceremony in the house of Nalia the day before the incident. I saw only one blood injury on Nathu's head in the hospital. I only mentioned the names of accused Tarun, Saso,
and Babu Changma in the Ezahar. Exhibit 1. I knew the name of the accused from the deceased before the Ezahar was lodged. Bimal Buragohai was with me when I went to the hospital and talked to the deceased. Bimal is still alive. Later, police questioned me during investigation. It is not a fact that I did not tell the police that deceased Nathu had told me the names of the accused persons who assaulted him. It is not a fact that I told the police that Tarun Changmai, Saso Changmai, Latu Changmai of village Chalaguri, along with some others, took Nathu to Karigaon and admitted him into the hospital for his treatment. It is not a fact that I did not tell the police the names of some Vishnu Saikia, Rontu Changmai, Diti Changmai. It is not a fact that Nathu did not tell me the names of any accused persons prior to the death. I did not witness the incident. It is not a fact that neither I mentioned in the Ezahar nor did I tell the police that I heard about the incident from my mother Punidoi. The distance between Loraputa and Karigaon by road is about 6 kilometers and across the field it is about 4 kilometers. It is a fact that I did not mention in the Ezahar as to where from I knew about the incident. I do not know if accused Tarun Changmai is blind. It has been later on proved, Lordship, by the prosecution itself that he is blind actually. It is not a fact that I did not have a good relation with the deceased. The people
Because
of
the mother apparently told him that these people had taken him to Karigaon.
Karigaon.
Had taken him to Karigaon.
Exactly, Lordship. I do not know if the accused
Mother should have been brought.
should have been examined, Lordship.
No, it's not. In fact, my lord, every PW statement is saying that all these, my deceased person was taken by all accused persons, and thereafter, my lord, nobody has seen that who has assaulted the deceased.
Any prior enmity or anything brought?
That is
Nothing.
not, there.
What has been brought, Lordship, is that the deceased conduct was not well. And also, one of the prosecution witnesses had admitted that actually there was an assault in the wedding, but he has not seen them, the accused persons there, the appellants there. And only later on, the appellants were seen taking him. And moreover, Lordship, one more thing has come during the cross-examination that Ananta Changmai, appellant number 1, was actually a friend of the deceased. So it could be different way also that they were taking him away from an incident.
What is his explanations? 313, any explanation?
They went for denial, Lordship. That is the problem. They all
And
went.
those three defense witnesses?
Defense witnesses stated about the conduct of the deceased, and they stated that they have not seen who was assaulted.
Conduct of the deceased in the wedding.
Not only in the wedding, throughout, because it is said that he had a tendency of being a drunkard, Lordship, and misbehaving with women. So that was brought out by the prosecution itself.
They could have in 313 said,
They could have, Lordship.
that
That
is the only opportunity they get.
Lordship.
Because in the first cross-examination, this defense, otherwise the foundation is there
Exactly, Lordship.
during cross-examination.
Exactly, Lordship.
It is not a fact that deceased Nathu forcibly enters the house of people of Loraputia.
Yes.
And when the women see him, they shut the door.
They shut the door, Lordship.
It is not a fact that when Nathu had committed untoward incident
At the wedding of
at the
Nadia.
wedding of Nalia's daughter, the people present at the wedding kept him tight. It is not a fact that Nathu was tight and assaulted at Nadia's house at night and was released in the morning. Yes. Okay, next.
Next is, Lordship, the deposition of PW2, Pavitri Saikia.
Who's he? Who's she?
She just went to attend a hokam. There was a hokam that day, so she was an attendant there. I know accused Tarun Changmai, Saso Changmai, Pinku Changmai, and Elias Sanjeev Changmai amongst the accused persons present in the court. I do not know the rest of the accused persons. I knew deceased Nathu Buragohai. Nathu died after he was tied and taken away by some boys. He died about 3 years ago. I went to attend the hokam at Suraj Saikia's house, and there I heard from the women that deceased Nathu was caught and taken away. I saw that accused Saso, Ananta, Tarun Changmai, and Latu Changmai caught Nathu and took him away. Later I came to know that Nathu died. Police questioned me. During cross lordship, one has to go to our village by crossing the river Darika and passing along the embankment. As one proceeds, first comes Kalia's house, Gethi's house, Nipen's house, Hogan's house, Bhadia's house, and our house, and then the forest consecutively. Thereafter comes the houses of Pinku, Elias, Sanjeev, and Tarun. Our houses are like farmhouse. It was holy on the day of occurrence. The hokam was organized in the house of Nipen. We were chopping vegetables. There was Simolu tree near the embankment. I did not see from where the deceased Nathu was caught and taken away. About 10 to 12 people gathered in the house where the Hokam was organized. Nathu used to roam around in our area. Deceased Nathu used to carry 2 dows. Nalia's house can be reached after crossing the river Darika. There was a marriage ceremony in Nalia's house the day before the incident. I do not know where Nathu was taken. I have been to Karigaon. It takes 2 hours to reach Karigaon from a village. There is a forest apart our village, and then comes a field. The field is not visible because of the forest.
Yes.
So even though Lordship here, she has stated she has seen them taking him away, but she has not seen from where he was caught. Now, Lordship may come to PW3, Lordship. Nripen Saikia. I know the 8 accused persons present in the court. I knew Nathu Buragohai. The incident took place about 2 years ago. I was at home at the time of the incident because there was my Bordetas Hokam in my house. I came out to the gateway and saw that accused Ananta Changmai, Sanjeev alias Pinku, Latu Changmai, Okoni alias Ranjan Changmai, Jadumani Kumar, and some others were taking Nathu away. Thereafter, I came home. The next day, I heard that Nathu died. Later, police called me to the police station and questioned me. I gave my statement before the magistrate at Sibsagar. Exhibit 4 is my statement given before the magistrate. During cross lordship, my house is situated at village Loraputa. Village Naujan is found just after crossing the Dorika river while coming from village Loraputa. One has to go across the field to reach Kumarpur, etc. from Naujan. The distance to Karigaon is about 7 to 8 kilometers by road. Houses of Kalia and Gethi and that of mine are situated near the embankment of our village. Then comes the houses of Bhogen, Bhadia, Padma, etc. And then comes the jungle. House of accused Pinku, Tarun and others are situated apart the jungle. There is a jungle apart the river and Nalia's house is situated near a jungle. The field is not visible from our house. I saw deceased Nathu Buragohai being carried away to the embankment, but I did not see him being taken to Karigaon. Nalia's house is situated about 200 meters away from my house. A day before the incident, there was a Murad Tel Dia ceremony at Nalia's house. The house of the deceased Nathu is at village Gorkush, which is at distance 2.5 kilometers from our village. The embankment to which Nathu was taken is 200 feet away from our house. I recognize Nathu and the accused persons. I do not know all the people at Karigaon. Many people were arrested after Nathu's death. Vishnu, Ranjan, Bhogen, Saikya were among them. It is not a fact that I was tutored as regards what to say in the court. It is not a fact that when I made my statement as per the dictates of the police, they set me free and kept the rest detained. That day, there was an annual Hokam in our house. It is not a fact that I did not see the accused persons taking away Nathu Buragohai. Nathu died in the hospital. It is not a fact that the people assaulted Nathu for creating a nuisance in the marriage at Nalia's house, and owing to that, Nathu was lying in the field and some people took him to the hospital and that later he died in the hospital. It is a fact that this is Nathu lived in the house of Nijora. This is Nathu was a friend of Nijora's son, Saso alias Ananta. That is appellant number 1.
He also just saw them taking away.
Yes.
Few of them.
All the witnesses, they only saw them taking him away.
Yes.
And Lordship, to corroborate this assault at the wedding, PW 16 admitted that there was an assault at the wedding.
Nalia's right.
Yes, yes, Sir Lordship. Now, Lordship, PW 4. I know accused Saso alias Ananta Changmai, Pintu alias Sanjeev, and Tarun Changmai present in the court today. I do not know the rest of the accused persons by appearance. I knew deceased Nathu Buragohai. He died about 2 years ago. At the time of occurrence, there was a Hokam organized in the name of my father-in-law. I was working at that function. Later, I heard from the children that Nathu was assaulted. I do not know who assaulted him. The next day, police asked me if I knew about Nathu's death. During cross, there was a pole bridge to cross the river Darika from Kalia's house. The pole bridge is about 200 meters from our house. Hokam was organized during the day hours at my father-in-law's house. My brother-in-law Nipen Kalia Nipen, Kalia, Simonto, and Bhogen were in the house where the Hokam was organized. The Nojawan field is not visible from our house. Subsequent to that of Nathu Buragohai, all the people of our village were called to the police station. Some of them were released from the police station and some of them were sent to jail. One can reach Nalia's house just after crossing river Darika. On the day of Hokam, there was a Mulot Tel Diya ritual in Nalia's house. I heard that there was a quarrel with Nathu in Nalia's house. Now PW4 also admits that she has heard about that occasion. It is not a fact that Nathu was assaulted and tied up at the wedding at Nalia's house. The people of Karigaon did not have any agricultural field near the house.
Yes.
Even Lordship, the Gaonbura was also arrested. Most of what sometimes reveals is that there was like a witch hunt which happened for the accused. And whoever was caught in the village were taken by the police into custody. And maybe thereafter certain favorable names were brought out just to make out a case. That's what seems like, Lordship, because finally even the Gaonbura has also admitted that, and the number of people who were present in in that group of people which went increased till 200. So even the Gaonbura said there were around 200 people who were there present at that day. So a constant change of the story in the prosecution, Lordship. And some had been seeing Nathu being dragged away. Some saw Nathu being carried away. Some saw Nathu being taken, walking along with them. Lordship, PW5, Lordship. I know accused Ananta Changmai, Sanjeev Changmai and Tarun Changmai who are present in the court. I do not know the rest of the accused persons. I knew Nathu. Nathu died about 2 years ago. There was a Hokam in our house on the day of occurrence. There I came to know that accused Saso, alias Ananta, Pintu, alias Sanjeev, Tarun, etc. caught Nathu and took him away. The children were shouting. I came outside and saw a crowd of people. Later I came to know that Nathu died. Our Hokam was not a Vitor Pukia Hokam.
What does the postmortem say?
Postmortem talks about injury by one blunt force.
Any suggestion was made whether that could be by a fall or something?
No, the medical officer was not examined to that extent also. So, PW 14. If I may, Lordship. During cross, our Hokam was not a Pitor Puke Hokam, a spiritual ritual where rice beer is served as an offering. When I heard that Nathu was caught and taken away, the elders of our family were inside the house. I cannot say now which children said so. Nalia's house is situated just apart the embankment of the river Dorika. I heard that Nathu was assaulted at the marriage of Nalia's house. Nathu died in the
So
hospital.
what it is looking right now is that maybe because he was creating a ruckus in the wedding, these people got hold of him and was taking him from the embankment. Because what has been seen is that people were taking him. Now to say that because he subsequently died, these are the people. The circumstances, then it is a case of circumstantial evidence, right?
Yes, Your Lordship.
The last scene, on that basis, perhaps it's too.
Otherwise, my lord, yes, from the evidences of the prosecution and the defense witnesses, it is clear that that concerned person, deceased person was not of good character, but that is an admitted fact, my lord, from the prosecution evidence and DWs also, my lord, somewhere. But at that point of time, one incident, he is a whatever his character may be, but ultimately this is a case of, in fact, a mob attack, my
Okay?
Like a
Case of-
lynching, maybe a public lynching, like kind of.
mob attack.
No, but where are those evidence?
Yes,
Because only one injury,
yes, that is the difficulty.
one injury,
Only one head injury. my lord.
one head
Head
injury,
injury.
which is
And
blunt.
The offensive weapon which was used from the allegation of the FIR,
Dao.
I think, rod and my lord, bamboo stick, and police has, my lord, seized one bamboo stick. Whether that stick was in fact used at the time of commission of the offense, that
That
is also, my lord.
is doubtful. And how far the class in theory will come here?
Lordship, on that context, since we are on circumstantial evidence, I'd just like to place a judgment before the Supreme Court. Lordship, 2020 to 19 SCC to 301, Lordship. Now, Lordship may come to para 9, Lordship, of the said judgment. Para 9 at para 9, Lordship,
Hmm.
304.
Yes.
In a case based on substantial evidence, motive assumes great significance. It is not as if motive alone becomes the crucial link in the case to be established by the prosecution. And in its absence, the case of prosecution must be discarded. But at the same time, complete absence of motive assumes a different complexion. And such absence definitely weighs in favor of the accused, Lordship. Furthermore, Lordship, para 11, Lordship,
These people are related to Nalia. That has also not come out.
only appellant number 1 is a friend of Nalia. Nathu.
Nathu.
Nalia is
No,
the
no.
person whose house the wedding
That's
was.
what I'm asking.
Yes.
You see, for them to get annoyed because he was creating this is Nalia or something also is not there.
Not there. The whole chain, Lordship, is not complete itself. Lord. There is not even a starting
No.
point.
But there's just one point. He was last seen.
Exactly, Lordship.
He was seen.
Yes, Lordship.
Now, when you were seen with these people, that was also for holding and taking. Now the onus is on the accused to explain. Here the accused is not explaining. Where is the explanation?
Lordship, that is true. That is
Now,
not-
when the explanation doesn't come, then how is the court going to look into it? So those decisions must be also brought to the notice of this court. You are carrying or not last sale clear?
Lordship. That is why, Lordship, I am on this whole concept of motive, Lordship, because going by your Lordship.
If you're right.
Yes, Lordship.
As of now, I am with you on all these things.
Lordship.
There's no motive. No witnesses have said anything more except holding and taking. The fact that the PW1 was told by his deceased brother perhaps is doubtful because he perhaps have never said that in his first statement to the police because in the cross that was put, so I'm sure it's not there. You can verify. But in the FIR also he mentions 3 names, 1 name. He doesn't even refer in his deposition. So that is doubtful. That part that his brother have said.
Lordship.
But not explaining
Lordship.
as why these people were carrying him,
Lordship.
whether that would,
The intent behind it.
yes, because apparently they were carrying him. It was the that owners was on the accused. The accused knows why they were carrying him,
Lordship.
isn't it?
Lordship is absolutely right. That has not been explained.
That has not been explained. Now, whether that would go against them
Lordship.
when there is no other evidence also to show that they may have done something, isn't it?
Lordship. Lordship is right.
Just merely because they were holding and taking.
Lordship.
Injury is also such which does not indicate that they all were attacking.
Lordship.
Only one injury,
One single blow.
which is also blunt.
Lordship.
Could be by a fall also. That is also not put to the doctor.
Lordship.
So that these doubts are there.
Lordship.
Now, not explaining vis-a-vis these doubts.
Lordship. The Lordship is correct.
Because first, general owner is always on the prosecution. That they have to prove it beyond reasonable doubt. This is not going to shift.
Lordship.
Just merely because he was seen doesn't mean that this will shift from the prosecution.
Lordship.
They have to first establish it beyond reasonable doubt.
Lordship.
Thereafter, you
Right.
see, if there is he was seen last, non-explaining of that perhaps then will not come in.
Lordship.
But isn't it?
Lordship.
I'm just thinking it like this. So I'm waiting for you people to show me authorities on
We-
these points.
We will, Lordship.
Because I think this is how this whole case perhaps needs to be looked into.
Look into exactly. Lordship.
Yes, anyway, yes.
Lordship. So, Lordship, we are done with PW 5. So we come to Lordship PW 6, Bhugen Saikia. I know all the accused persons present in the court. I know the deceased Nathu Buragohai. Nathu Buragohai is no more. The incident took place about 3 years back. The incident took place at around 9:30 a.m. on the day of occurrence. I was taking blessing in the Hokam of Bordeuta. I heard children shouting outside that Nathu was caught. I came outside and saw accused Saso alias Ananta and Pinku alias Sanjeev Changmai taking Nathu towards Karigaon. I got back to my work. The next day, I heard that Nathu died at Shivsagar Hospital. While giving my statement to the police, I told what I've stated
And
today.
there is also a fact that he was drunk.
Yes.
So the postmortem shows that he was,
No, that part was not examined, Lordship.
because you see, that doctor could have been asked. It could be that he's so drunk that
He fell down and got injured. Exactly, Lordship. Lordship, this is what I see in most of my legal aid cases, that certain very important points are not been taken now,
that is the problem.
Lordship. Exactly.
That is the problem. This is where you need these stakeholders, prosecutors, and police to be trained. It was very difficult.
Very true, Lordship.
The prosecutor ought to have asked these questions to the doctor,
Lordship.
isn't it? Especially when it is blunt. If it was not blunt,
Yes,
it would have been different.
exactly, Lordship.
Now that you can't leave these doubts unexplained.
Lordship.
If these doubts are unexplained, then the prosecution case will fail.
Exactly, Lordship. That's why, Lordship, Hukum Chand judgment was very specific on the role of a public prosecutor.
Very, very important.
Yes, so
Here, so many doubts are coming.
exactly.
You know, mother was there. Mother was also not brought,
Exactly, Lordship.
and the bamboo stick was not sent for
No,
examination.
examination. No.
Whether the bamboo stick had blood or not. Is it clear? Have you seen the Caesar?
Yes,
Blood is there.
yes.
Blood stained.
But still,
No.
regarding that, there is no.
It's silent about blood.
How are you connecting the bamboo stick?
Yes,
And moreover,
Who has
Lordship,
seen a bamboo stick in their hands?
Lordship, the bamboo stick was found in a field.
No, that's what I'm saying.
Exactly.
Who has seen the bamboo stick?
Right.
Prosecution only talks about lathi rod, or sorry, rod, dao, and something like that.
Exactly, Lordship.
Yes, Mr. Das.
Lordship. I know the accused person present in the court. I know the deceased Nathu Buragohai. Nathu Buragohai is no more. The incident took place about 3 years back. The incident took place around
These
9:30.
people are in jail now.
No, Lordship, that was confirmed. They are on
my
bail.
lord, as per my instruction, my lord. My lord, they were initially, my lord, put behind jail on 23/8/2011. Thereafter released on bail on 1/11/2011. my lord. So for a period of 3 months.
Yes.
Lordship, I was taking blessings in the Hokam of Bordeuta. I heard children shouting outside and Nathu was caught. I came outside and saw accused Saso alias Ananta and Pinku alias Sanjeev Changmai taking Nathu towards Karigaon. I got back to my work. The next day, I heard that Nathu died at Shivsagar Hospital. While giving my statement to the police, I told what I've stated today. During cross Lordship, Kalia and Gathi were present in our Hokam. The Hokam was at Nipen's house. Nipen was in the farmhouse. Accused Tarun Changmai was also there. Only I came to the outside. No one else came out leaving the Hokam. None but I had witnessed what had happened. Now, this is a totally contradictory statement, Lordship, to the other witnesses who have stated that we came out and we saw.
What is said here?
No one else, Lordship, third line, no one else, only I came to the outside. No one else came out leaving the Hokam. None but I had witnessed what had happened.
Yes.
There was a pole bridge on the river Darika near our house. Nothing beyond river Darika is visible from our house. The embankment of Darika is about 200 feet away from our house. I saw the backside of the accused persons and Nathu. I did not see who was holding Nathu. I have said that Pinku and Saso alias Ananta took Nathu away because the kids said so. Now, this is very important, Lordship. One point he is stating that he saw them taking away and he is the only witness to it. Now he is coming and saying that he has just named the people because the kids have told him so. That these are the people taking him away. The children who were shouting were about 5 to 7 years old. When I returned, Jolpan was being served to the devotees. I did not say anything to anyone inside. I did not see who went in which direction after crossing the embankment. The field of Karigaon is not visible from our house. The house of deceased Nathu is about 4 kilometers away from our house. The house of Nalia is situated apart the embankment. I did not attend the marriage in Nalia's house. The next morning after marriage, I heard that Nathu was assaulted at the marriage in Nalia's house as he had created nuisance there. Nathu had friendship with the accused Saso alias Ananta.
But whatever he otherwise came outside and saw accused, Saso, Ananta, alias Ananta, Pinku, alias Sanjeev taking Nathu towards Karigaon. And later he says, I could not recall, I said that Pinku and Sashu alias took Nathu because the kid
The kid
said
said
so. So he have not seen.
Exactly. Roshi. And he is stating below your, he's again confirming that there had been a fight at the marriage when Nathu was creating a nuisance. So Rashid, the whole concept of even if there was a blow impacted on the accused or on the deceased, who had impacted that blow? That has never been brought into light by the prosecution. Also.
Nothing has been approved, it looks like. Sorry, Mr. Bhattakar, I'm yet to hear you, but
Yes, my lord.
the way it is
I have also
going,
gone through those all these prosecution witnesses. my lord.
unlawful assembly,
Yes.
you have convicted so many accused. For what? Where is the meeting of minds, sharing of the common intention? You can't assume all this merely because some 1 or 2 persons saw few of them holding and taking.
At that point of time, one incident happened, and because of that incident, my lord, victim by disease, the expert.
But whether that is sufficient,
Yes, my lord, during evidence, my lord, all these things, my lord, whether.
whether that is sufficient,
Yes.
because it is apparent that he was taken because he was creating a ruckus in Nathu's house, in Nalia's house.
14,643.
That part is prosecution itself. Prosecution is saying that it's your prosecution's version that some ruckus have been created by the deceased, isn't it? Now it is obvious that if someone is creating a ruckus, he will be taken away,
But, yes.
isn't it? And it doesn't say anything more than taken away.
Only taken away,
Correct.
and thereafter all are silent later. on.
Correct. I
On the
could
next day, we came
understand
to
these
know that.
people were saying that these people assaulted him.
Yes, yes.
Correct. That is not coming. Taking away.
On that, Lordship, one more judgment I'd like to rely upon.
You give your judgments together.
Okay, Lordship.
Anyway, give.
Yes, Lordship. I'll just read out and I'll just hand over. It's a settled law that mere presence or association. It is a settled law that mere presence or association with other members alone does not per se be sufficient to hold every one of them criminally liable
That is
for the offense
correct.
committed.
Standards, usually a passerby or a standing person, you can't just bring him.
Exactly.
So something more has to be seen.
Exactly.
Here now, at least, even if not 2, let us say 1 witness is there who have said that all the accused were taking him.
Yes. Lordship.
Now let us say that is there.
Exactly.
Whether that itself is sufficient to bring home
304.
to constitute common intent, the meeting of minds and sharing of intention, because that is required for
For 304.
first unlawful assembly.
Exactly.
Unless unlawful assembly is established, you can't convict all of these for 304, isn't it?
Exactly.
Anyway, we'll resume at 2.
Lordship.
My lord, sorry to say, my lord, at 2, my lord, today I have some difficulty, your lordship.
Oh,
My lord, some personal difficulty, my lord. Can it be
Is it?
possible on Tuesday, my lord?
today is Thursday.
Next Thursday.
Next Thursday?
Don't take it too far.
Thursday, Lordship.
I'm quite otherwise.
Yes.
I have invested a lot of time today.
Lordship.
Yes.
So if you take it to Thursday, we don't know what again will happen on
Because
Thursday.
Lordship, I'll be actually leaving for Kolkata on Monday. So I will be back only on
Tomorrow?
Thursday.
Tomorrow, your
Tomorrow,
lordship,
again, Lordship, there is some problem, Lordship.
Thursday.
Thursday, Lordship.
Thursday आरो matters আছে নেকি?
Because Lordship, we can start from PW7 on that day. We can finish it off on that day, Lordship.
How do you expect the court to remember all this, Mr. Das?
Lordship, yeah, I'll make a note for you, Lordship, with all the evidence and
It is difficult,
Lordship,
and especially in criminal matters.
every single fact matters, Lordship.
Thursday কৰিব পাৰে?
sorry, my lord, otherwise I would have.
No, if you would have told me, because so many going by 23 witnesses, it was not possible to finish it
Lordship,
in the first half. Huh? এটা আছে পাৰ্থৰ Thursday. তেতিয়া ঠিক আছে। No, but otherwise পাৰ্থৰ এটা আছে না? এইটো কৈ দিব Thursday কাৰণে। Okay?
deeply obliged, Lordship. Thursday, oh, next Thursday, next Thursday, আজি তো Friday হৈ গ'ল, Thursday হৈ গ'ল, next Thursday. দুটা বজাত বেলেগ একো নাই, 4 and 5 দিব।
মোৰ ল'বলৈ বেয়াও লাগিছিলে, হ'ল কি উপায় নাই, কি হ'ল
উপায় নাই। মই ভাবিছিলো কোৰ্টে কৈ গৈছিলে, হেৰিংটো মই আৰম্ভ কৰি দিলে পইণ্ট দুটা দি দিলে যেন কোৰ্টে প্ৰায় আগৰ পৰা ল'লে, এতিয়া কি কৰিব পাতিব পাৰিছো আৰু 23 আছে, সেইদিনাটো কিমান টাইম
মই এই কৰোঁতে বেয়াও পাইছে, মই ঘপককে মাজত টাইম
কোৰ্টে
উপায় নাইকিয়া হ'ল। মই আগতে ক'লো নেকি, আগতে 11 চনৰ আকৌ আজি কেনেকে টাইম
একজেক্টলি
মই ভাবিলো শেষ হৈ যাব বুলি হ'ল।
ঠিকে আছে দিয়ক আহোঁ, থেংক ইউ, লগ পাম।
এই যে এই 3 বান্ডিল আছে এই 3 বান্ডিল আছে তাক কইছো রে বোনা নাই কি কোন এটা তো ভিডিওস দেখায় এটা একটা এনে ধরার মানুষ আয়া এটা এক মাস আগে আছে আপনার কারণ করে দিলা আলো ওই ভাবিস আর কি আছে কি লাস্ট এই প্রজেক্ট করতে এইবিলাক মানুহ ধ্যান কৰে। এইবিলাক মানুহ কৰি কাম কৰাব লাগে।
which were already typed, otherwise it gets delayed. Sorry, yes,
My lord, item number 10, my lord.
Yes.
Lordship, we have already concluded our argument.
yes.
Today, my lord, the petitioner was supposed to submit, my lord, list of that only. And I have submitted records also.
No, because item 10, I was thinking of dictating it in the court only. So,
Yes.
we, I got, I think, Mr. Chaudhary, you have a part heard?
No, my lord, we have prepared, last time lordship indicated that we should submit written argument, we have prepared it.
We filed it also.
We have filed it also,
on record.
Which one is yours?
3 and 4.
3 and 4.
3 and 4. No, not 3. 3 is.
4 and 5, sorry, 4 and 5.
4 and 5. In 4 and 5, you have filed your written arguments.
Yes, ma'am.
Disa. Or other side kuna sir.
Statement.
No, they've also filed. They've also filed.
Everybody is there.
Hmm.
So I will just say that the written arguments have been submitted and I'm just going to post another.
Another date.
Let me have a look at it. Because 10, apparently I am ready to, so let me do it
We leave it to lordship.
if it's not inconvenient.
No, it's not at all.
4 and 5, Marshwa, heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. R. Singha, learned counsel for the petitioner. Also heard Mr. P. Sharma, P.P. Datta, learned counsel appearing for
Public Service Commission.
APSC. Anybody else is there? Stop.
P. Nayak will be appearing for
P. Nayak.
And Mr. P. Nayak for the state
finance
of
department.
finance, additional advocate general. Now, and then say the written, last order to sound. Which date?
It was on 25.
No, next date, any? Next Thursday, so after 19.
13 na lage, 13 na.
So,
This written submission by R2 was filed today. R2.
No, they have served us the copy few days back.
Few
So
days.
we have filed on Monday.
Monday. It is submitted that, no, the petitioners have, Mr. R, no, you said the petitioners have filed their written arguments on, Monday.
Day for yesterday.
Yes, yes.
Monday date, give that date, so and so. It appears that respondent number 2 has also filed their written statements on 5/6/2025. In view of the last order passed by 25/2025. Relist on 24/6, for further hearing. Mr. Singha,
Yes.
you, before 3 days, you remind my court master about this case. Then I will look into, because no point of looking into the written arguments now.
Yes, yes.
Just 3 days before you remind,
surely-
I
yes,
will
I'll-
have a look at the written arguments, and if I can, that
We'll
on,
do that.
on the next date, I will dictate.
Deeply appreciated.
Here that, the only issue was,
involvement in the Alpha.
which may apparently, it looks like the criminal court has already acquitted.
Equitable.
Some submission, written case laws, this bunch is given by you.
My lord.
Ashwin, this is for final disposal, huh? What about this? Who has given this?
Ajoy.
No, this is given by you.
Oh,
Mr.
Ajay Kumar Singh,
Chutia. You have given this. GM Tank.
The GM thing also I submitted. Malad.
Yes, yes. And some corruption, Nagpur. Ramchandra, this is given by you.
No, Malad, I submitted two cases, Malad, Ajoy Kumar Singh and GM thing. Ajoy Kumar Singh was in.
Who prepared this note? This note, it dekhai diokson, it কোনো
I have submitted one, Malad, gist.
Where is your gist?
It too. Yes, Malad.
That is your note.
Yes, my note, Malad.
Because there are three decisions.
This, Malad, with this note, Malad, I submitted the case law.
Which were the case laws?
Z tank,
G tank.
GM tank, yes, Malad.
Gita case law could call. Gita to only call. कितना हासिल है तुम्हारी लिखने में Right. Just sort this out once. Who has given which one? Just write it. This has been a
Yes,
little
yes.
confusion
Yes,
here.
yes, yes.
Because should I just write down which is
Yes.
the case that you are relying, and you just write down the one. They are all kept together. Did you? Sorry. দুটা ক্লিপ লৈ লওক তেওঁলোকৰটো বেলেগে দিব এইটো বেলেগে দিব
These two cases also.
Got it? And that note that you had prepared,
Malad?
that note is there? You said you had prepared a note?
Yes. This one, Malad.
এখন তেওঁৰটো দিয়ক Yes. Heard Mr. R.C. Borpatro Gohai, Learned Senior Counsel, assisted by Mr. R.D. Fukan, Learned Counsel for the petitioners. Also heard Mr. T.C. Chutia, Learned Additional Senior Government Advocate for the state respondent. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned order of discharge of the petitioners, two petitioners,
There are two petitions.
of the petitioners from their service and for reinstatement thereof. The brief facts of the case is that while the petitioners were serving as constables in police department, a case 37 of 94 under the TADA Act was registered as Simolguri PS, wherein the petitioners along with others have been named as accused. In view of the allegation in the criminal case to the effect that the petitioners were having close contact with Alpha and they are indulging in the activities of illegal outfit, comma, the Commandant First AP is R5, right, Mr. Fukan? The respondent number 5, by his order dated 1/4/1994, discharged the petitioner number 2 from his service with effect from 31/3/1994. And the full stop, huh? However, the Superintendent of Police, Golaghat, Superintendent of Police, Golaghat is 3. However, the respondent number 3, don't say Superintendent, huh? Respondent number 3 initiated a departmental proceeding under the departmental proceeding number 3/94 by order dated 24/6/1994 against the petitioner number 1, alleging that he was found involved in Simolguri PS case number 37/94 under section 3(4) of TADA Act. Thereafter, upon completion of the inquiry, the respondent number 3 asked the petitioner number 1 to submit his reply to the second show cause notice dated 15/6/2004. No, thereafter, after completion, huh? Thereafter, upon completion of the inquiry, comma, the respondent number 3, by order dated 27/10/2004, discharged the petitioner number 1 from his service. Thereafter, the petitioner number 1 submitted an appeal before the deputy. Is he also a party? Before the respondent number 2, wherein No, sorry, submit an appeal, na? Before R2. However, the same was rejected by order dated 27/4/2006. Thereafter, now in the meantime, in the criminal case, the charge sheet was submitted against 6 accused persons, including the petitioners. And upon completion of the trial, the criminal court, by judgment and order dated 21/7/2012, acquitted all the accused persons, including the petitioners, from the charges leveled against them. Being acquitted from the criminal case, comma, the instant writ petition has been filed for setting aside the impugned discharge order. Mr. Porpatra Gohai, learned senior counsel, submits that since the petitioners have been honorably acquitted from the charges framed against them in the criminal case, comma, the departmental proceeding being based on the same charges, the order of discharge is not justifiable. He further submits that the charges in the criminal as well as departmental proceeding being identical, comma, the decision of dismissal of service, the impugned order of discharge from service warrants interference from this court under Article 226 of the Constitution of India. In support of the aforesaid submissions, he relies upon the following decisions. Number 1, 2006, Volume 5 SSC 446. Number 2, 2024, volume 1 SSC 175. Number 3, 2025 SSC online SC 890. 2013, volume 1 SSC 598. 2013, volume 3 SSC 73. Stop. He further submits that in respect of Dipen Dwara, who was named as accused number 3 in the criminal case, though was initially placed under suspension, no departmental proceeding or any other disciplinary action was initiated against him. And the Supernov Police Jorhat is respondent number, and the respondent number so and so,
Number 4. Number 4.
and the respondent number 4 by order dated 31/12/2008 revoked the order of suspension and reinstated the aforesaid person. He accordingly submits that there being a discrimination in conducting departmental proceedings, inasmuch as a person with similar charges was reinstated after trial, the impugn order of discharge is bad in law. In support of the aforesaid submission, he relies upon the decision of the Apex Court in the case of -- reported in 1991, volume 1 SSC 609. Mr. Borpatra Gohai, this person, Dipen Gogoi, against him, the trial was also acquitted.
Yes, Lordship.
So that trial was before the disciplinary proceedings were drawn.
Yes, my lord, only on the basis of that order of the honorable.
Okay. He further submits that the petitioners are entitled to adequate compensation for their suffering due to the arbitrary, unjust, and unreasonable acts of the respondent authority. And to buttress the aforesaid submission, he relies upon the decision of the Apex Court in the case of such and such, reported in 2025, SSC Online, Supreme Court at page 890. Mashwai, in this branch, you will, in the second page, you will get all these references. And these case laws are all here. So you, against the citation, you please put the party names in that where I have, okay, understood? Per contra, Mr. Kot kolte our case logita? Our case logita kot ase? Oh, sorry, it is. Per contra, Mr. T.C. Chutia, additional senior government advocate, submits that submitted that unless and until the accused is acquitted honorably and completely of the charges, it would not be expedient comma, the power of authority the power of the disciplinary authorities to continue the departmental proceeding inquiry is not taken away, nor its discretion in any way is fettered. Correct?
Yes.
This is what you were saying.
Yes, brother.
Stop. In support of the aforesaid submission, he relies upon the decision of the apex court in the case of so and so, following cases of the apex court, okay? Number 1, 1981, 2 SSC 714. Number 2, 2006, 5 SSC 446. Number 3, 2005, volume 7 SSC 764. I have given my prudent consideration to the arguments advanced by the learned senior counsel appearing for the petitioner, as well as the learned additional senior government advocate for the state, and have perused the materials available on records. I have also duly considered the case laws cited at the bar. It appears that the writ petitioners have been discharged from their services while they were discharging serving as constables in the police department. On the basis of the allegation that they were having close contact with Ulfa and were indulging in the activities of illegal outfit. It further appears that upon the petitioners being acquitted and exonerated from the aforesaid charges by the criminal court, the instant writ petition has been filed seeking setting aside of the dismissal, discharge, impugned discharge order. Stop. The short question that arises for determination in this writ petition is whether the the exoneration stroke acquittal of the petitioners in the criminal case would render the impugned discharge orders issued to the petitioners unjustified. Stop. Apt at the outset, the charge sheet is there in the disciplinary proceeding. Have you annexed? No.
Show cause notice was issued, and after inquiry report, submission of inquiry report, second show cause notice was.
Where are they? You have it? I just want to,
In the records is there, Malad.
where are the records?
Record, yes, yes. I can point out.
You just point out the
Yes,
charge sheet or the
yes, yes.
memorandum of charges.
First show cause notice is page 17.
No, where is the records? Asan nahi kita?
Record is there, Malad.
My lord, will find in our additional affidavit,
Additional affidavit, yes.
yes, annexer F. And annexer G.
Annexure F.
Annexer F and
Yes.
annexer G.
This
Page
is your
41.
second show cause notice.
Yes, my lord.
What about the first?
First is there, my lord.
In our records is there, Malad.
I'll take it from records. It's all right.
Page 17.
Page 17.
Yes, flag mark is there. Malad.
Annexer P. My lord, in our writ petition, annexer B, page 12, my lord.
Annexure B is a show
Ah,
cause notice.
In our, yes, my lord, in our writ petition, my lord, at page 12, my lord.
No, 12 I got.
Yes, yes.
12, oh yes. All right, I stand corrected. I just want you keep those pages ready, huh? The
My-
first show cause notice and then that is followed by the disciplinary
Reply.
and
Yes, sir.
orders. And then I think a second show cause notice and then the discharge order. I'm going to quote all that in my order. So keep the pages ready. Mr. Barpatra, go ahead, take your seat.
Thank you.
I just want this basic assistance. Mr. Fukan is good enough for that.
My lord.
Uh, Now you say, apt, what did I say? Apt at the outset to refer to the first show cause notice issued to the, this is one petitioner, no?
Arun Kaur.
That is number, petitioner number?
Petition number 1, Madam. Petition number 2 against him, no disciplinary proceeding was drawn.
Oh, here, correct.
No,
Here.
Against petitioner number 1,
Arun.
did I give you the date? I gave you the date. That show cause notice issued to petitioner number 1 by notice dated, is it 5/6?
A matter of allegation is there.
Now that first show cause notice date is 20? Yes, 24/6/1994. 24/6/1994, huh? Top. Which reads as under, quote unquote, page 12. A to A. Okay? Reading of the aforesaid show cause notice, it is apparent, it is clear that the allegation contained, the allegation level, the allegation that the charge, that the petitioner number 1 is charged with the allegation that he is an active member of the ULFA and he managed his appointment in the police department with a view to bring disgrace to the police department as well as espionage for the Alpha. Stop. It appears that thereafter, departmental proceeding was initiated against the petitioner This is 13, page 13. Departmental proceeding order, Mr. Fukan. What is page 13?
13 is the reply to the second one.
13 is an order.
Page 14 of the set.
Page 13 is what?
To the end of page 15, the order is there.
Oh, this is finally. Yes, this is the departmental proceeding order, isn't it?
Yes.
Departmental proceeding where
Dispose of.
what did you write, Marshwa? Wherein in the inquiry, comma, the inquiry officer examined 3 prosecution witnesses being, where do I get the name of the 3 prosecution witnesses?
Yes, sir. One Pushpa Bora,
One, SI Pushpa Bora
Simoluguri PS,
of Simolguri PS, comma,
one Jyoti Prasad Fukan,
Jyoti,
JYOTI,
Jyoti, Jyoti
Fukan.
Prasad,
informant,
Jyoti Prasad,
Fukan,
Fukan,
and
informant,
SI Nandolal Hazarika.
and
SI Nandolal Hazarika.
no, what is his name?
Nandolal
And Nandalal
Hazarika.
Hajorika,
Yes, ma'am.
comma, SI, which police station? Simalguri,
Shimaluguri.
SI Simalguri PS.
That's it.
It appears that on the basis of a confessional statement made by the petitioner number 1 before the
Superintendent of Police.
Superintendent of Police Sipsagar,
Sister.
stroke respondent number
Okay, is the respondent number 4.
4, and on the basis and no, so and so held the petitioner number 1 guilty of the aforesaid charge. It appears that thereafter an appeal was filed which was rejected by the appellate authority.
Thereafter, the second so-called notice was issued.
Oh, after the appeal,
No.
before the appeal.
After the conviction order, before the conviction order, my lord.
No, this appeal is after second show cause or before
It
second?
is after second show cause.
Okay.
After second show cause, my lord, this appeals order was passed. Page 12.
No, 1 second. Second show cause is given here. Second show cause is 15/6/24. And this appeal order is
Appeal order is, my lord,
27/4/06. Okay. Don't say appeal, huh? Thereafter, a second show cause notice was issued to the petitioner This is also not correct. The second show cause notice is already agreed. It's a preconceived mind. It appears that thereafter a second show cause notice was issued by notice dated 15/6/2004, whereby the petitioner number 1 was informed that the inquiry officer appointed to inquire into the charges leveled against him by departmental proceeding number 3/94 of Golaghat has submitted his findings upon completion of his inquiry, and that on going through the findings of the inquiry officer, the departmental authority agrees with the aforesaid findings of the inquiry officer and has provisionally come to the conclusion that the petitioner number 1 should be dismissed from his service immediately. And accordingly, put the petitioner number 1 to notice. The aforesaid notice dated 15/6/2004 is reproduced here under for ready reference, page 48, huh? A to A. Reading of the aforesaid second show cause notice, it is clear that the departmental authorities before issuing the second show cause notice to the petitioner has already decided that the petitioner is guilty of the charges leveled against him and that the petitioner should be dismissed from his service. Petitioner number 1, huh? Stop. It further appears that thereafter, yes, this where is the order? Discharge order?
Page 15. And exactly.
That thereafter the departmental authorities by order dated 27/4/2006
Revoke public service. As part what, after. It's 16.
removed the petitioner number 1 from service with immediate effect, within bracket, with effect from 25/10/04 with a DO number 3944 dated 25/10/2004. It further appears that ultimately the criminal court acquitted the petitioner number 1 and the petitioner number 2 from the charges based on which they were found guilty in the departmental inquiry and discharged from their services respectively. Criminal court's order
At page 17. Page 17.
the criminal court vide judgment and order dated 21/7/2012. Say 21/7/2012. A perusal of the judgment and order of the criminal court indicates that on the basis of an affair alleging inter alia. That the informant had received a secret information that some Ulfa extremists have been taking shelter at Soprai Borpathar Gao, and upon conducting a search in the aforesaid location, some Ulfa related documents were recovered from the possession of one Kamal Hussain along with Babul Kuar, Golab Ali, alias Pankaj Gogoi, who were
Elias.
Golab Ali alias Pankaj Gogoi, who were taking shelter at the location. And upon being interrogated, the aforesaid persons, and upon being interrogated, it was learned that the aforesaid accused persons were involved in some anti-social activities and were members of Bent Ulfa organization. Accordingly, a case was registered, and after completion of investigation, charge sheet was submitted against the aforesaid persons as well as against the petitioner number 1 and 2 stop. Now, in this order, where do I see that those 3 witnesses of the departmental proceedings were also witnesses here?
Get it page 31 of the petition.
No, I mean in this order.
Yes, Lordship, that is annexed in with the order at page 31.
Yes. Jyoti Prasad Fukan, right?
Yes.
Then,
Pushpa Bora
Pushpakanta Bora,
and Nandolal Hazurika.
which is the other one?
SI Nandolal Hazurika.
Nanda?
Lal.
He's not.
Nandolal Hazurika.
I don't think he's here. Nandalal Hazarika.
Lordship, PW3, that is Krishnakanta Sharma,
Huh.
and PW6, that is Pushpakanta Bora, both their name has been reflected.
And what about Jyoti Prasad Fukan?
The
He's not there.
Lordship, he is not there. Only 2 names are given.
It appears that the 2 witnesses who had given whose statements were recorded in the departmental proceeding to come to a conclusion of guilt against the petitioner, number one, were also examined as prosecution witnesses before the criminal court. It further appears that no, it don't say it further. Apt to refer to the relevant paragraph of the criminal code of the trial court judgment. A to A, page 27, para 37 onwards, huh? A to A, huh? Page 27, 28. And paragraph 43 at page 29. 43 and 44. 45 also. 43 to 45. Yeah. Reading of the aforesaid judgment and order of the trial court, it is clear that the confessional statement based on which the inquiry officer hold the petitioner number one guilty in the departmental proceedings in the inquiry held was found to be not proved in the criminal case. That apart, it appears that the that there is no evidence to that the prosecution has failed to establish that the petitioner number one is a member, is an active member of the ULFA organization. It is further clear that the trial court, the criminal court, after perusing the evidence, was of the clear opinion that the prosecution has miserably failed to prove its case through the evidence of the witnesses on record. and accordingly acquitted the accused persons, including the petitioner number 1 and 2, including the petitioners. Stop. As a necessary corollary to the above, the question that arises is whether such acquittal by the criminal court would render the impugned discharge orders issued to the petitioners unjustified. There can be no doubt that the two proceedings, criminal and departmental proceedings, are entirely two different proceedings and operate in different fields and have different objectives. However, in the event the allegation stroke charges are identical in the criminal as well as departmental proceeding, and the witnesses are also that of same, where the when in such cases the accused is acquitted honorably and completely exonerated of the charges, comma, continuation of the departmental inquiry on the very same charges and or the order of discharge thereof is not justifiable. However, mere acquittal in criminal case shall not preclude the departmental authorities from taking an action if it is otherwise permissible, or automatically render the order of discharge unjustifiable. In other words, the context, in other words, the allegation, comma, list of witnesses, and the manner in which the acquittal has been reached and or granted is to be seen. In the present case, 1 second, huh? Mr. Chutia, the other day you fairly agreed something. What was that?
That was a page 90 confessional statement.
Huh?
Confessional statement.
Confessional
Page
statement.
9.
Page 9
9, yes.
of the
Of the records, my lord. Black mark is there, but last.
yes. What were you saying from here?
Here he put his signature on the confessional statement, and he says that this is not my statement.
Here itself, no?
Yes, last.
To ever
Page 9, but I will show it.
in the present case, it appears from the records of the disciplinary proceedings that the confessional statement based on which the departmental proceeding, that the inquiry officer has held the petitioner number 1 guilty of the charges leveled against him though was signed by the petitioner. However, he has stated that please tell me.
Yes, sir.
However, he has stated, কৈ দিয়ক।
Oh, yes. Here he stated, putting his signature, গোটেই স্বীকাৰোক্তি পঢ়ি চালো, এইবিলাক কিন্তু মোৰ নহয়।
Where, however, he categorically stated that after reading the confessional statement recorded therein, it is not his version.
That is the
The same is not, however, is not his version.
personal statement.
Correct.
Yes, yes.
It further appears that that in the criminal trial, in the criminal court as well,
Side.
the confessional statement of the prosecution had miserably failed to establish and prove the confessional statement alleged to have been made by the petitioner number 1. Correct?
Yes.
So, it is further apparent that the witnesses examined in the departmental proceeding is also the same, were also examined by the criminal court, and upon analyzing the evidences, the criminal court has completely exonerated the petitioner from the charges, which is identical. Reasonable doubt, yes, I know, but that is
Benefit of doubt.
that you see, Mr. Chutia, that is of course any criminal court will say, even I will say that.
Yes.
But that you can't. You have to read it together. You are right, Mr. Chutia. But before that, it has also said miserably failed. What did you say? Identical. Sorry, I will just read it again. Which is identical as that of the departmental proceeding. As that of the department. Stop. Apt to refer to the decision of the apex court in Maharana Pratap Singh, Supra, wherein the apex court has held as under, quote unquote, 24, 25, 26, 27. Pertinent that in respect of the petitioner number 2, there was no departmental inquiry initiated, and he was discharged from his services merely on the allegation that he is an active member of Ulfa organization, which on the basis of the allegation made in the criminal case. It is apparent that in the criminal case, the criminal court has fully exonerated him of the aforesaid charge. Thus, the petitioners, having fully exonerated from the subject allegation, from the charges based on which they have been discharged from their services, is not justifiable. That apart, it appears that the departmental authorities, after completion of the departmental inquiries, before issuing the second show cause notice along with the copy of the inquiry report to the petitioner number 1 to show cause as why the petitioner number 1 should not be, as to why the inquiry report should not be accepted, has already agreed with the findings of the inquiry officer and have also decided to remove the petitioner from the service. issuance of opportunity stroke second show cause notice is not an empty formality. In fact, it is an opportunity given to the delinquent to explain as to why the inquiry report should not be accepted, which is submitted against him. Therefore, while giving him the opportunity, if the departmental inquiry authorities have already agreed with the finding of the inquiry officer and has also decided the penalty, comma, the same would render the second show cause notice obsolete and an useless formality, which should be against the principles of natural justice. Having held so, having noted that in the present case, the departmental authorities has already agreed with the finding of the inquiry officer and the proposed punishment, the discharge, the impugned discharge order on that count also is bad in law. In the foregoing, the continuation of the discharge, impugned discharge orders would be unjustifiable. Accordingly, the impugned order of discharge of the petitioners from their services being order dated, first one is 2710, 2710/2004, and they both were different, na? What about petitioner number 2?
And 27.
And 1/4/1994. Correct? And 1/4/1994, right? Huh?
Before 1990.
Please check, because if that goes wrong, it'll unnecessarily have to come again. Respectively,
Yes, Lord.
is set aside and quashed. Resultantly, the respondents are directed to reinstate the petitioners in service with all service benefits. Accordingly, the writ petition stands allowed. Mr. Counsels, don't expect the order today. There will be some editing and all. All right? Mr. Chutia, the records, I will release it by tomorrow, huh?
Yes.
Because while editing, I might have
Yes,
to.
yes. Tomorrow I will collect it. Obliged, madam.
Lordship,
Yes.
Lordship, item number 15, we are waiting. Mr.
Item
Sahil.
number
15,
15.
second appeal, your Lordship. RSA, your Lordship, my,
When do you want it?
or third week, 17 or 19, your Lordship.
All right. As jointly prayed for by Mr. G.N. Sahewala, Learned Senior Counsel, appearing for
Appellant.
appellant as well as Mr.
Yes, Ali.
S. Ali, na? As Ali, Learned Counsel, appearing for the respondent, relist on
17,
17. No, not on 17. 17, 18, you leave it. Any other
After
day.
vacation, my lord.
19.
After vacation.
Huh.
After vacation, did
Date
you?
date may be fixed.
On such and such
Huh?
date.
17 July.
Anybody else?
My lord,
Come.
item number 18 and 19, my lord, it has wrongly been listed for hearing.
Acha, wrongly listed
My-
today.
No, my lord, it should have been come for admission hearing, my lord, instead of
Acha.
listening.
18 and
19.
you are for?
I am for respondent number in item 19, I am respondent number 7, my lord.
Huh?
Respondent number 7 in item number 19.
Where is the petitioner's counsel?
My lord, petitioner for
18 and 19, it is submitted by Mr.
J.C. Gordon.
J.C. Gore, Learned Counsel, appearing for respondent number 7, that this matter ought to have been listed for admission hearing.
My lord.
However, it has been wrongly shown in the hearing column. Let registry verify and place it and list on any date to be fixed by the registry under the proper column.
My lord.
18, 19. You are there?
Yes, my lord. For the demand.
Yes. Then you say Mr. S.C. Gore along with Mr. P. Nayak, S.C. Gore for R7, along with Mr. P. Nayak, Learned Additional Advocate General for the state respondent.
Of that.
Yes, please.
My lord, I am of course for item number 9, my lord.
Yes.
My other side is,
No, we are present.
Huh?
He's coming, he's coming.
Second appeal.
second appeal.
এতিয়া তাৰ ওপৰত আৰু কিবা আছিল নেকি? 6 and 7, anyone there?
I am appearing on behalf of NM Hazarika for appellant, I am appearing
Where? In which one?
in 7, item
No,
number.
in 6. Let us first take one by one, Arutya.
6.
Item 6. Yeah, fine to do. In item 6, you write. None appears for the parties on call, relist after 2 weeks on any date to be fixed by the registry. 7.
I am appearing on behalf of Mr. NM Hazarika for appellant. Due to health issue, he is not coming today, so.
When do you want it?
After vacation,
In item 7, huh? You are Mr.
B. Fukan,
B.
B.
For Bombay.
Bombay.
Mr. B. Fukan, Learned Counsel for the appellant, submits that who is unwell today? Who
NM
could not?
Hazarika,
Huh?
NM Hazarika. NM Hazarika.
Mr. N.M. Hajorika, Learned Arguing Counsel, could not come to court due to
His health issue.
his medical health issue, and accordingly seeks a short accommodation in the matter. Prayer is not opposed. When do you want it?
After vacation, nothing.
Relist after 3 weeks? 4 weeks ho jabo niki? Vacation hole? After 4 weeks on a date to be fixed by the registry.
Request.
Where is the respondent? Yes. The second appeal.
Yes.
Oh. Pani দিব দিয়ক না। I have heard writ petition, criminal petition, then
Now the second appeal, my lord. Civil.
also one quashing petition in the morning.
Yes, yes.
Yes.
My lord, this appeal is against the judgment of reversal. What happened, my lord? The suit was filed by the present appellant as plaintiff before the courts below.
Where is the substantial question of law?
Substantial question of law is, my lord, whether the learned lower appellate court committed error of law in not considering the judgment passed in title appeal 87 of 1958 by the Judge Kachar, Silchar, and by the Honorable High Court in Second Appeal 200 of 1961, wherein the plaintiff's tenancy right over the suit land was established. And another, my lord, was the judgment of the London Lower Appellate Court below suffered from infirmity in not considering the evidence of the plaintiff in respect of their right over the suit land in its proper perspective.
So, but this is a factual question of facts because appellate court has considered and has reversed. Now, the appellate court can always appreciate and reappreciate the.
Of course, this.
Correct. The appellate court has that power. Unlike the second appellate court. Before the second appellate court, now you have to show that a substantial question of law is involved. Of course, the question which has been framed is open now to see by the court. Before the court goes into it, the first question that has to be decided is whether the following two questions are substantial questions or not.
That's right.
Correct. It is only once this court is satisfied that these are substantial questions of law, then the court will have to further go into and examine. However, the court is not going to sit in appeal against the findings of fact.
First appellate court.
This is the settled position. The question prima facie, Mr. Counsel, prima facie it shows is not of substantial question of law. You think of it, we can hear it on another date. You think over what the court has said because you have to be prepared in that manner. These are factual issues. I think this is going to be your
That's right,
argument.
exactly.
This is your argument, isn't it?
Yes, yes. And there is a decision from the direct Supreme Court.
Correct,
That's
correct.
enough, my lord. Upkin number.
When do you want it? Tuesday?
The next.
Board matters as any Tuesday. Thursday.
Tuesday, 10 तारीख पड़ा 10 तो ना. Let it remain so much.
10. All right. Relist on 10. If you can satisfy me that the questions are of substance, then another thing.
Lord.
But it doesn't look like you have those decisions
Lordship,
ready on that day.
Lordship, I'll place the Lord.
Yes. Yes.
May I please, Your Lordship?
Second
Lordship
appeal.
means- Yes, Lordship. Lordship, I am appearing on behalf of Mr. P.K. Dekar. Lordship, in this case, Lordship, the appellant expired, Lordship.
Huh?
Appellant expired.
Okay.
And after that,
So
Lordship,
you-
we were not able to contact with the hires, Lordship, legal hires. Lordship, so the matter is abated, Lordship. Lordship may pass any order.
Is abated, my lord? Then
We are not able
Provision.
to, Lordship.
Wait, what is that provision in CPC?
my lord, it is order 22, rule 3 here.
Only sole appellant. Sole appellant.
Told.
We have tried to contact Lordship, but we
Order rules.
Order 22, Your Worship.
দিয়ক না CPC খন দিয়ক No, but there are two appellants, no? Hari Krishna Raha and Srimati Junurani Raha. You have the proper instruction
Worship,
that two repellents,
yes, Lordship. We
Which-
tried to contact, but we were.
both have died over.
No, Lordship, according to them only, so we have known, Lordship, that the appellant is died, Lordship.
Huh? Who has died?
Appellant.
Which appellant?
Appellant number 1.
But what about two?
Who is the wife of Hare Krishna?
So then
We have
the
no instruction.
appeal will only stand abated against one. The appeal will go on, two is there,
Yes.
isn't it?
Yes, ma'am.
The CPC con, put goal. Just give me that provision.
Order 22, Your Worship.
কি কৰিলা ৰূপক?
Order 22.
এখেতক দিয়া, ইফালে দিছা কিয়? No, কোৰ্টৰ CPC খন ক'ত আছে? আৰে কোৰ্টৰ CPC খন দিয়ক। তাত দি দিছে কিয়? এখেতক দিয়ক উলিয়াই দিব।
এইটো order 22.
আমাৰ ইয়াত যোন পিয়ন থাকে ক'লে গ'ল আজি? এখেতৰ কিতাপখন ঘূৰাই দিয়ক। Yes, which one? Order 22, Rule 1,
Rule 4. Your Worship.
Rule 4.
They were defendants in the court, ma'am. Rule 4.
Where one of two or more defendant dies and the right to sue does not survive against the surviving defendant or defendant known, or a sole defendant or sole surviving dies and the right to sue survive, the court on an application made itself cause the legal representative of the defendant to be made a party and shall proceed with the suit. Within the time limit, no application is made. When do you have the date of expiry? When?
No, Lordship.
So you have to give all this. How will we do it all this without knowing? You find out. Who has given you the information that the appellant number 1 has died?
We have, my lord, but we have no proof, my lord.
And
No.
you are giving that information to
Yes.
the court.
On
You
August,
you see, Mr. Counsel, you are the counsel representing the appellants, right? It is your duty to find out whether the appellants are alive or not alive. Have you sent a registered post letter?
Yes, Lordship.
Where is it?
Lordship,
Where is the registered post letter? Has the registered post letter been received, not received? Where are those? You file an appropriate application before this court. This court cannot just simply, you're not even sure. You don't even know which appellant. You are relying on the respondent counsel.
in the month of August 24, it was, my lord, informed, my lord.
You find out,
August 24.
you have to have a death certificate or something.
Only they can collect, my lord.
Correct. So you get it, the information. Mr. What's your name?
My lord, in that 127.3, they were given the last chance, my lord.
What is your name?
127.3. On 27.3, my lord, they were asked that they should take the information in the last 27.3, 24, 27.3, 25.
But they are saying legal heirs of the appellants. They are not even sure. You ask Mr. Medhi to be here on the next date.
I'm only, Lordship, Medi, joint of Medi, J Medi. I'm appearing
No,
on
no,
behalf of
Decca.
Mr. P.K. Decca, Lordship.
Correct. You asked Mr. Dekar to be here on the next date. Mr. J. Medhi, Learned Counsel, appearing on behalf of Mr.
P.K. Decca.
P.K. Dekar, Learned Counsel for the appellant submits that they are not being able to contact the legal heirs of the appellants. He further submits that he is not aware as out of the two appellants, which one has expired. Let Mr. relist after 2 weeks on a date to be fixed by the registry to enable the counsels appearing for the appellant to apprise the correct position before this court, to place the correct position before this court.
My lord, after 2 weeks, my lord, a date may be given. Otherwise, it is very difficult for listing, my lord.
No, nowadays
Second-
registry does it.
Oh.
Yes. Next.
Item 13.
13.
Item 13.
My lord,
None.
this, my lord, matter has a connected RSA, my lord.
14.
The same subject matter, my lord.
14.
13, my lord, 13.
13 and in 14 also I saw your name.
Yes, my lord. My lord, 13 will be, my lord, maybe listed along with RSA 201.
In item 13, you write, as prayed for by Mr. M.J. Kadir,
Yes, my lord.
learned counsel appearing for the appellant, relist along with RSA
201 of 16
201 of 2016
Yes.
on any date after 2 weeks to be
My lord,
fixed by
after
the registry.
That matter is fixed on 17, man.
Then on 17 so and so 17 June.
Yes.
On 17 June there could be a difficulty.
Or no.
Along with so and so
Along
on a date to be fixed by the registry.
Yes, 14 minute I am here, but
You are there.
yes, my lord, I am.
Other side is not here.
Yes, I is not.
Heard Mr. So and so Kadir, learned counsel appearing for the appellant, none appears for the respondent on call. Relist after 2 weeks on a date to be fixed by the registry.
Okay.
16.
15 to keyhole. Yes, Miss Yadav.
Lordship. Your Lordship, my senior is on legs in court number 19. Kindly pass over the matter for time being.
What time being? You see, there is time. You want this court to now sit after the court hours also. At the fag end, you want a time being. That also a second appeal. Yes, Miss Yadav, when?
As your lordship, I am ready.
Heard MS item number 15. K Yadav, na?
Yadav.
MSK Yadav, learned counsel appearing for the appellant. Also heard your name.
B. Chauhan.
MS B. Chauhan, learned counsel appearing for the respondent. MS Chauhan submits that the arguing counsel, Mr. S. Chauhan,
Yes.
is on legs in another court and seeks accommodation accommodation accordingly. Stop. Prayer is not opposed. Relist after
As your lordship, any day.
3 weeks on a date to be fixed by the registry. It's a 21 matter, right?
17.
Find your friends.
Lordship, yeah, for the appellant, it
Yes.
cannot be possible today.
Looks like 22. When do you want it?
A date may be fixed.
After vacation, Lordship.
After vacation, you want a date? That date is as jointly prayed by Mr. P. Bhattacharya.
BK Bhagavati.
Sorry?
BK Bhagavati.
Sorry. BK Bhagavati, learned counsel appearing for the appellant, and Mr. D. Chaudhary,
Yes.
learned counsel appearing for the respondent. Relist
6.
on
5 and 6.
respondent number 5 and 6. Relist on such and such date.
Like,
That's okay.
on the second July, no?
Lordship,
Yes.
for the intrusion. Lordship, I to mention item 18 and 19. I'm from the petitioner's side. Lordship, the issue is that it's a tender matter, your Lordship. Just
18 and 19 not keyhole. Ki disu? Somebody had made a
yes,
mention.
somebody mentioned we haven't been informed. That's the issue. Lordship, the issue is that it's a tender matter. There's a status quo order. Despite having the status quo order, they're continuing with the war. At this rate, it will be ultimately become infructuous. That's why I'm seeking a date, your Lordship.
All right. 18 and 19. Oh, no, correct. No, I've been informed that that matter is supposed to be listed for admission hearing. However, it has come in the hearing column, so I've directed it to the registry to fix it to list it before the appropriate column. Which date you want? Tell me.
12th of June. Lordship.
Huh?
12th of June,
12th June.
next week.
12th June. Okay. Then you give it the registry before the appropriate column on 12th so and so.
Lordship,
The status quo is need not be continued, right?
Lordship,
No, it is still a fixed date or it was till today.
Lordship, it has been maintained. Lordship.
Oh, then it's okay.
Lordship, item 14 also on 12th June, Lordship.
14 we
Item
have
14.
all, I think we have given an order.
16 matter, Lordship, 2016 matter. Thank you. 14 to